the appeal. D. We can have it some other day, but
Yes, madam.
notice may not be necessary. Okay.
Well,
If somebody enters the appeal, it's a different matter.
Right.
It's a regular appeal or amicus? Jail appeal?
Jail appeal, madam.
Do Miss M. Burman, learned amicus, is present for the appellant? Appellants, huh? A prayer for adjournment has been made by Ms. B. Bhuya, learned APP, Assam, Para. In view of the above, list after 2 weeks.
As it is item number 4, Mr. K. Goswami's name is shown for the amicus. Someone else to be appointed.
Okay. Item number 4. Item number 4. In view of the subsequent development, comma, we appoint 3 15 Navakumar Kolita to act as the amicus. In this case, on behalf of the appellant, let a copy of the paper book be served upon him by the registry within a week. Full stop. The matter may come up for hearing after 3 weeks. Kindly inform him.
Fine.
Navakumar Kolita.
Fine. Okay.
Occasional dated 24/3/25 shows that service upon the respondent 2 years already been completed, my.
Okay.
Is there a service report?
Yes, my. Just a black mark is there.
Involving POXO?
My.
24/3.
27 to they have
7/2. Date is not there. Your J. Laskar
My.
heard Sri J. Laskar, learned counsel for the appellant, who has drawn the attention of this court to the office note dated 24/3/2025 on the aspect of service of notice upon the respondent numbers 2 and 3. Full stop. As per the said office note, the service has been affected. Also perused the enclosure to the same, which are acknowledgement receipts by the respondent numbers 2 and 3. Full stop. Para. Since the service is of recent origin and the said respondents have not entered appearance, we adjourn the matter by 3 weeks to enable the respondents to appear. Full stop. In case the said respondents choose not to appear, comma, this court, comma, an amicus would be appointed as the conviction involves the POCSO Act. List after 3 weeks.
Right.
Let us wait if they may appear.
Yes, sir. Hope it finishes it today.
Lordship, I will take it.
My Ramzan month is going on, so by 3, Lordship will.
When this court is having some difficulty, but since we have heard substantial, otherwise we are not very inclined. Some personal difficulty. Okay, we'll try.
I have made written argument, the chart and everything, so it's.
इसी तो सॉरी बनेगा ना
Your Lordship, on last occasion, Your Lordship, I have shown this exhibit, Your Lordship. One exhibit that I have shown is the Caesar list, Your Lordship, from which
You have shown exhibit 1, scissor
Lord.
list, and exhibit 3, the inquest.
Lord. Now, Your Lordship may kindly come to exhibit 6, that is the Your Lordship post-mortem report. Injuries are mentioned, Your Lordship, in page 807. Injury number 1 is a stab injury. 2,
Just a-
3, 4
Where
is
is the PM report?
Lordship 807.
Yes.
Lord. Injury number 1 is the stab injury, Your Lordship.
Page,
Page 807, Your Lord.
injury number,
1, Your Lord. External appearance.
yes,
Then your
injury
lord.
number 1, yes,
Lord.
right.
These are Your Lordship injuries.
Mm.
Need not go through, Your Lordship. Just Your Lordship pointing out, this is the according to the Honorable Trial Court, Your Lordship, Lion Trial Court, this is the fatal injury, and according to the medical expert, Your Lordship, it may be fatal, Your Lord. The word specifically used may be, Your Lord. That Your Lordship in his evidence, Your Lord. And then, Your Lordship, injury number 2, 3, 4, and 5, Your Lordship. These are, Your Lordship, injuries, Your Lordship, where contusion is there, Your Lordship. And in the judgment, I will So your lordship, the learned judge has held that this is not major injuries, your lordship.
2, 3.
2, 3, 4, and 5, your lordship. 5, your lordship, two ribs are found fractured.
Hmm.
Page 808,
Yes.
lord. Now your lordship may kindly come to page 811, opinion.
Yes.
It says, death was due to shock and hemorrhage following the injuries sustained as described, which were antemortem homicidal in nature. Injury number 1 was caused by sharp cutting pointed weapon, and injury number 2, 3, 4, and 5 are caused by blunt weapon. However, viscera, blood were preserved for chemical analysis. He has not, your lordship, mentioned, your lordship, that the injury number 1 can cause, your lordship, death, your lordship. Then your lordship may kindly come to page 817, your lordship. And 818.
8.
17. This is the notice, your lordship.
2.
2D, your lordship, reporter, your lordship, 43 and 40, 42 and 43, your lordship. PW. Your lordship will kindly note the date, your lordship. This is exhibit 9, your lordship. 14 September 2019.
This reporter Utpal is PW.
PW 43, your lordship. 42, your. PW 42. And your lordship, then on 14th he was directed, and 14 itself, your lordship, he give this certificate under section 65B, your lordship. Page 818. This, your lordship, I want to place, your lordship.
Where do you get the date?
That, your lordship, at the, your lordship will get it, your lordship. At the top, your lordship.
Where?
817, your lordship. No, 818, your
Oh,
lordship.
818. Where is the date?
821, your lordship.
Hmm?
Bottom, your lordship. Or 819, your lordship. Second page, your lordship. 14.9. Eight one nine. Your lordship got it. Now, your lordship, there, your lordship, there is a reference to the mobile number, then mobile handset. This is the handset from which the data was transferred. Then, your lordship, page 819, your lordship.
Hmm.
These are, your lordship, 1, 2, 3, 4, your lordship. These are all, your lordship, what is there in the statute, your lordship, they have reproduced it. 5 is important, your lordship, clause.
Hmm.
The above said mobile is working condition till today, that is 14 September 2019, when the output was taken from aforesaid mobile. The data transferred on CD has been taken directly from mobile by connecting with the computer system through data cable, Your Lordship. This is important, Your Lordship, will kindly see. So far as this transfer from the mobile to computer system and then to Your Lordship in CD, the 65B certificate is only in respect of the mobile, Your Lordship, not in respect of the computer system, Your Lordship. Ultimately, Your Lordship, 65B certificate will have to be in respect of the computer system also, Your Lordship, because computer system, as we have seen from these evidences, Your Lordship, is not belong to this person. He has transferred in the police thana itself. That means, Your Lordship, it belongs to the police, Your Lordship. Number one. Number two, Your Lordship, will kindly see this. From record, we have seen, Your Lordship, these 42 and 43 has said that these video footages he has handed over on 3 days after the incident, Your Lordship, to the police. 44 says, Your Lordship, which is a crucial witness for the prosecution, that I have been shown after 3 or 4 days, I was called to the Thana and I was shown video footages from which I can find out the person, Your Lordship. This specific, Your Lordship. That way, Your Lordship, these video footages, the veracity, genuineness of these video footages, Your Lordship, under challenge, Your Lordship. That cannot be, Your Lordship, cannot be said that the genuinity of the video footage, Your Lordship, I am questioning, Your Lordship, based on this, Your Lordship. I will show from Your Lordship the Evidence Act, Your Lordship, 65B. Now, Your Lordship, rest, Your Lordship, will find that the same kind of 65B certificate relating to different videos, Your Lordship.
No, see, the transfer from the mobile was on a CD.
Lordship.
He has certified that the contents of his mobile, regarding his certification is on the contents of his mobile.
Mobile, Your Lordship.
And he is also involved in transferring the data from the mobile to a compact disc. And compact disc you cannot just directly transfer.
That computer system.
It has to be done through a
Cross
computer.
system.
So where is the further necessity of 65B for
Because, Your
computer?
Lordship, ultimately, Your Lordship, finally, when it was uploaded in the computer, Your Lordship, it is the computer system which, therefore, Your Lordship, sanctity of that computer, Your Lordship, will have to be, Your Lordship, disclosed. That's what, Your Lordship, is the intent of this particular provision in the Evidence Act, Your Lordship, so that, Your Lordship, it cannot be tampered with, Your Lordship. That's the point, Your Lordship. That is why, Your Lordship, necessary to do it. This is my submission, Your Lordship.
No, what according to you means not according to as in our proper procedure. As per you, what would be the proper procedure?
According to me, Your Lordship, in my humble submission, Your Lordship, along with this 65B certificate in respect of that particular mobile, he will also give us 65B certificate in respect of, Your Lordship, this computer system also, Your Lordship. That's what's the intent, Your Lordship, of the provision, Your Lordship, which is not there, Your Lordship. And this assumes significance in view of the evidence of the PW 44 as well as the PW 42 and 43, which says they have given these evidences to the police, Your Lordship, 3 days after the incident, Your Lordship. These are rest are, Your Lordship, the similar certificate in respect, no need to, Your Lordship, show. Then the same way, Your Lordship, so far as PW 43 is concerned, his, Your Lordship, certificates and notices also in, Your Lordship, exhibited, Your Lordship.
43 is also a journalist.
43 also journalist, Your Lordship. 2 journalists, Your Lordship. Your Lordship will get his notice at page 854 on 14th September itself. And 855 is the certificate. And in fact, your lordship will get at page 884 is the fingerprint gurus, your lordship. It 884 and the how they have, your lordship, collected the chance fingerprint, your lordship. Now, your lordship, these then, your lordship, from 889 onwards, these are 164 statement, your lordship, of the protected witnesses, your lordship. More or less, your lordship, they have, your lordship, what they have stated before the police and before the magistrate, your lordship, Colonel Magistrate, and they are
889 onwards, what are these?
these are, your lordship, 164 statements of the witnesses, your lordship,
164.
164. All of them are protected witnesses.
Almost Kalan is nice, huh? Fishpal Tehri might be some. Serotic Fishpality might be like. Marriage with you. Not a very good job. Madam of no silence. Madam, please see 889. Whether this is going precarious, I have asked you to put a cell of this. 889.
Oh, okay, 164 statements.
889 page. 882.
880. Oh, this one.
Already gone.
This is gone.
See? Lekin this will go. Salary to lagai lo. Prani kotha kori ekhan to lagai dibo.
Oh, here, it's here. It's here.
Exhibit 48 to 54.
Just a minute.
Listen.
Asano chalbe?
এই নোটটা তোমরা টাইপ করে
Oh, madam auto provide. Yes.
Look, from 48 to 54, your lordship, these are the 164 statements.
889.
Lordship, 889 onwards, your lordship. So
These are protected witnesses are number?
your lordship,
P- PW?
PW, your lordship, Pavitra Sahu.
No, numbers from?
Lord, PW, from your lordship, 32, then 36 to 41,
32.
and then 36 to 41.
These are protected witnesses.
These This is your lordship, more or less your lordship, what they have stated before the learned magistrate is your lordship. As stated before the court, don't need to your lordship go through again and again, since your lordship has already gone through. Now your lordship will kindly take up the judgment.
Which one page?
Your lordship, the third volume, your lordship,
Volume 3,
volume 3 of the paper.
page
Your lordship, it starts from page 543. Your lordship may kindly come to 572. Para 6, your lordship.
yes.
One only on your lordship, one first 5 lines I am showing your lordship. During investigation, the IO had visited the place of occurrence, examined the witnesses, and also got the statement of 7 witnesses recorded in the court under section 164 CRPC. The IO also made a prayer before the court under clause 7E of the Witness Protection Scheme 2018 for protection of 7 witnesses by concealing their identity, as the said witness received threat to their lives, and the same was allowed by the court. Your lord, this is your lordship.
Yes.
And your lordship has seen from the evidence of the IO, your lordship, that on 6th, your lordship, they were taken after keeping them for a few days, your lordship, in the police station. Then they were taken. Application was submitted on the 5th, and on 6th order was passed, your lordship. Now your lordship will.
What is the purpose of highlighting this?
This is because your lordship, this is not as per your lordship Witness Protection Scheme of 2018. Your lordship. The mandate of the 2018 scheme has not followed, your lordship, while passing this order under witness protection. I will show from this particular scheme, your lordship, how it was not followed, and this scheme, your lordship, has been framed by in pursuant to a direction by the Honorable Apex Court, and Honorable Apex Court in judgment in 2019 has categorically stated that this is the law under Article 142 of the Constitution of India. Till a statutory mechanism is framed by the government. And when, your lordship, this particular trial was going on, your lordship, that judgment of the Honorable Apex Court was invoked, your lordship. Then your lordship may kindly come to page 575, your lordship. I will not, your lordship, burden your lordship by reading all these, your lordship. Those only which I feel, your lordship, necessary for my case, your lordship, I will show those. Para 18, your lordship.
Page?
Page 579. May I read, your lord?
Yes.
It is to be mentioned here that the date, time, and place of occurrence is not disputed by the defense side, but the learned defense counsel in the written argument submitted that admittedly the complainant Sri Manoj Gogoi PW3 has not prepared the Azahar Exhibit 2. It was drafted by his assistants of namely Sri Muktajyoti Borua PW28, the Soumen Kundu PW21, And PW 28 came to know about the names of the accused that were present in the mob from one Prakash Rajwar and welfare officer Jiban Kurmi. Your Lordship will kindly note here, Your Lordship, this Prakash Rajwar, Your Lordship, who has the first identified this person, has not been examined by the police, Your Lordship.
What about the Jiban Kurmi?
Jiban Kurmi also, Your Lordship, what he has said, Your Lordship, he has not seen the incident, but during cross, Your Lordship, he says that these are the persons who are present in the veranda of the hospital, Your Lordship. And also, Your Lordship, the dresser of the hospital, Subhas Rajwar, he has also not identified, Your Lordship. I will again show, Your Lordship. As well from the other staff. But who are the other staffs, Your Lordship? This part has not been investigated, Your Lordship, not been disclosed, Your Lordship. But the prosecution side has not examined Prakash Rajwar as witness here in this case. It is further submitted that PW1 and PW52 Jiban Kurmi has admitted that they did not see the accused person assaulting Deven Dotto. Besides, the IO has not mentioned in the FIR the date of receiving the same, and as such, the FIR and the names of 30 accused persons mentioned therein, according to the learned defense counsel, is doubtful. But having considered the submission in the light of facts and circumstances of the record, we find no force in the same. PW3 has identified as many as 12 accused in the court, and he categorically stated that he learned the names of the rest of the accused from the staff as well as seeing video clippings, Your Lordship. Your Lordship, video clippings, Your Lordship, assumes importance, Your Lordship. By when he filed this FIR, lodged this FIR, he has seen this video clipping. Either this available video clipping is that from the, Your Lordship, the two journalists, PW2, 42 and 43, Your Lordship. They said they have given it to police, Your Lordship, 3 days after, and Your Lordship, police has actually seized on it. It is on 14th, Your Lordship. Now, where is this video footage came, Your Lordship, based on which, Your Lordship, he has identified and named this person, Your Lordship. That's an important, in my humble submission, lacuna in this particular case, Your Lordship. It is a fact that he did not state before the IO that he learned the names and other accused persons from the staffs and video clippings, that it was not asked to him. This being brings the position to the defense side cannot take benefit of the same. It is also a fact that IO has not mentioned the date of receiving the FIR Exhibit 2, but he has clearly stated, having mentioned it in the printed copy of FIR, therefore there is no scope for any doubt about the date of receiving it. It is also a fact that Prakash Rajwar is not cited and examined here as here in this case as witness, but his non-examination here in this case as witness caused no dent to prosecution case in as much as the evidence of other prosecution witnesses are clear, cogent, and sufficient enough to establish the same.
Where are you reading, Mr.
Page
19.
para 19.
Yes, yes. Yes.
It is also a fact that the Prakash Rajwar is also not cited and examined here in this case as witness, but his non-examination here in this case as witness caused no dent to the prosecution case, in as much as the evidence of other prosecution witnesses are clear, cogent, and sufficient enough to establish the same beyond all reasonable doubt. It is also a fact that PW52 has not named any accused in his examination sheet, but it is elicited in cross-examination the names of as many as 24 accused, of whom he identified 9 accused by name and others without name. He had found all of them either on the veranda of the hospital or in front of the room of the doctor. It may be mentioned here that this witness could not enter into the chamber of Dr. Deven Dotto as he was assaulted by mob in veranda of the hospital. Thus, the submission of the defense counsel in respect of the FIR is found to be devoid of merit. It may be mentioned here that FIR is not the encyclopedia of the crime. Its object is set to criminal law in motion. Reference in this context can be made in a decision of the Honorable Apex Supreme Court in Kirendra Sarkar and others versus State of Assam. Now, Your Lordship, pausing here for a moment, Your Lordship will kindly note, Your Lordship, that in the FIR, he has not mentioned the name of the Sanjay Rajwar as the person who inflicted that injury in the thigh, Your Lordship. That is there, Your Lordship, which has been filed, lost, Your Lordship, 6 hours after the incident, according to him, after he was all along there, number 1, Your Lordship, PW3D informant. And apart from that, Your Lordship, he has seen the video footages, Your Lordship. He has taken information from all persons, Your Lordship, but this person was not named, Your Lordship. And in fact, Your Lordship, that in my humble submission, Your Lordship, failure to mention the name of Sanjay Rajwar, Your Lordship, at the lodging of the in the FIR, your lordship, is a relevant fact for consideration by this honorable court, your lord. It is also a para 20, your lordship. Para 20 speaks about
Yes,
Para 20 speaks about, your lordship, the FIR subsequently lost by the father of the son of the deceased, your lordship. Therefore, your lordship, I will not, your lordship, read it again. Then your lordship may kindly come to charge under section 302 and 302 149, page 582, para 23.
para,
Para 23 onwards, your
yes,
lordship. 24, your lordship, is the evidence, he has discussed the evidence of medical expert, your lordship, doctor, your lordship. An injury as mentioned in para 25, your lordship has already gone through in the post-mortem. Maybe doctor. Your lordship may kindly come to para 27, your lord. Doctor vision 33. 33. In his re-examination, your page 586. In his re-examination by the prosecution side, PW 33 testified that the injury number A can be caused by material exhibit 21 and injury number B can be caused by material exhibit 4 and injury.
third is the doctor
Doctor, your lordship.
who conducted PM.
Lordship.
How do you delete the last line? Injury number A alone.
Lordship, that is what I am trying to show, your lordship. Your lordship, when the evidence of your lordship is this is doctor is re-examined, your lordship, he has not said like that, your lordship. What he said, your lordship, that injury number A may be solely responsible for the cause of death, your lord. Now there is a vast difference between maybe and, your lordship, solely responsible for, your lord. The use of
113.
lordship. Maybe solely. If maybe what had not been there solely responsible, then it's a different thing, your lordship. The moment he says may, your lordship, it alternatively it also means may not, your lordship,
Re-examination was by whom?
by the prosecution, your lordship. Since, your lordship, these parts were not there in the earlier in the examination, your lordship, therefore is re-examined, and then, your lordship, two things they brought, that the particular weapon, your lordship, that glass, your lordship, that may cause the death, your lordship, cause the injury, your lordship, that was brought, and then, your lordship, these words, your lordship. And in fact, your lordship, there is, your lordship, initially learned court, your lordship, has recorded that injury number A is solely responsible for the cause of death, then it was corrected and then your Lordship it is put maybe your Lordship.
Where do you
In
get?
evidence,
India, okay, India.
PW 33 your Lord.
You are at page 113.
Lordship,
Is it 113?
113. Then your Lordship will kindly come to, there are para 35 your Lord. Mob of around 40 people in the Garden Hospital premises, creating ruckus and shouting, and he then proceeded to the doctor's chamber and tried to inquire as to what had happened. Then the mob started attacking Dr. Deven Dotto. Then he tried to protect him and pleaded the mob to stop the assault and calm down. But they did not listened to his request and continued attacking Dr. Deven Dotto with fists and blows and kicks. After some time, some policemen came and tried to calm and control the mob, but the mob got more aggressive and threatened policemen and also pushed them. The mob did not allow them to protect the doctor. By this time, the crowd had also increased to about 200 people and started breaking the glass panes of windows and doors. His effort to protect doctor failed and they continued to attack Dr. Deven Dotto. His evidence also reveals that after some time, some more police personnel as well as magistrate arrived at the Garden Hospital, but the mob did not allow them to do their duty and the crowd was so big that they surrounded the Garden Hospital. After some time, they have been able to move the people out of the room. By this time, he noticed that Sri Deven Dotto was bleeding profusely from his left eye. Then one of the security persons with a pipe of saline bottle tried to tie the cut portion of the thigh to stop bleeding. Finally, after much effort, the magistrate was able to evacuate Dr. Deven Dotto and the dead body of Samara Maji from inside the hospital, and Dr. Deven Dotto was taken to the MCS for medical treatment where he was declared brought dead by the attending doctors. This evidence also reveals that later on he came to know that one patient, namely Samara Maji, got injury in his toilet of his home and was brought to Garden Hospital at around 3:15 p.m. Then hospital researchist Subhas Rajwar immediately informed the Srimati Ranjula Bora, staff nurse, who came immediately and attended the patient. She then called up Dr. Deven Dotto, who advised her to give the patient Dexona injection. Dr. Deven Dotto also arrived at there and tried to treat the patient in his nebulizer room, but subsequently he died. Then a crowd of about 40 people stormed into the Garden Hospital and threatened the hospital Chokidar, the Suresh Rohidas, and also threatened the nurse Srimati Ranjula Bora, and stopped the hospital dresser Subhas Rajwar from trying to protect the doctor. Later, Jibon Kurmi, the welfare officer, also came to help Dr. Deven Dotto, but he was assaulted and sent away. At that point, only he came to know that Garden Hospital, PW25 Subhas Rajwar, dresser of the hospital, and PW26 Srimati Ranjula Hazarika Bora, staff nurse, also corroborated this piece of evidence of PW3, though they have not named any accused who have caused hurt to Dr. Deven Dotto, as because PW25 have no occasion to seem the same who left the hospital out of fear having seen assaulting the welfare officer by the mob, and PW26 was new to the place. Now, Your Lordship, this welfare officer, Your Lordship, Jibon Kurmi, Your Lordship, he has not talked about any assault, Your Lordship, as such, Your Lordship. PW40, Para 40. His evidence also reveals that while doctor was taken to the hospital, he remained present at the Garden Hospital and pacified the mob. And after their dispersion, he instructed his assistant Muktajuti Borua and Somen Kundu to find out the names of persons involved in the incident. Thereafter, he proceeded to Jorhat Medical College and Hospital to follow up the treatment of Dr. Deven Dotto. His evidence also reveals that he could recognize the persons present in the mob, but he does not know their names. Subsequently, after inquiring about the incident through his assistants, other office staffs, as well as welfare officer Juban Kurmi, he came to know the names of culprits and accused. Further, his evidence reveals that the accused persons present in the court, he could recognize accused persons, so namely so and so to 12. He came to know the names of other accused persons from his office staff as well as seeing video clippings. It is also reveals that Dr. Deven Dotto was also assaulted by broken glass pieces besides his first fist blows and kicks. His evidence also reveals that he was present when the police held inquest over the dead body, Dr. Deven Dotto, and took signature over the inquest report. He then lodged the FIR with the TIOC PS. His evidence also reveals that he came to know that over the date of Samara Maji, incident of this case had taken place. The defense side had cross-examined the witness at length, and it is elicited that Exhibit 2 was lost at the police station on 31/8/2018 around 10 p.m. by his assistant Muktajuti Borua. It is also elicited that he did not state before the police the names of other accused persons, which he learned from his office staff as well as seeing the video clippings, as he was not asked by the police. It is further elicited that accused persons whom he had identified in the court, he knew them by their faces but did not know by their names. It is also elicited that from WhatsApp and video clippings taken by one person whose name he don't want to disclose due to security reason, he came to know about the involvement of the accused persons named in the Azahar, but the defense side has failed to confirm the contradiction through IO. Now, Your Lordship, what they have already admitted, there is no question of confirming it through the IO. What we have elicited, he has admitted, Your Lordship. Now the learned court below is saying that I have not confirmed it through the IO. The only when he will deny my suggestions, then only the question of confirming through the IO will come, Your Lordship. Otherwise not, Your Lordship. But the defense side has failed to confirm these contradictions to the IO, and as such, the same cannot be pressed into service, Your Lordship. This is completely wrong, Your Lordship. It is an admitted fact that he did not mention the names of accused Kalang Maji and Manoj Maji in the FIR. Exhibit 2, the learned defense counsel in his written argument has assailed the evidence of this witness on the ground that he had not visited the police station to file the FIR and that his statement was recorded after 4 or 5 days of the incident, and he did not know the names of the accused and he did not state the names of the accused before IO, and as such his evidence cannot be relied upon. Whereas the learned special BP has submitted during argument that PW3 is a manager of the TIOC Tea Garden and the entire occurrence took place before his own eye. He was in a state of shock and also fears. As such, it is natural that he omitted to state the names of the accused before the police. On that count, his evidence cannot be thrown overboard, Your Lordship. Now, he has not stated in his evidence, Your Lordship, that he was under fear, Your Lordship. It was, Your Lordship, these are all presumptions, Your Lordship, and conjectures, Your Lordship. The learned special PP has referred to one case law, Vikas Chaudhary versus State of Assam, in support of his submission, wherein a division bench of this Honorable Guwahati High Court has held in paragraph 29 that non-disclosure of the names of the assailant at the initial stage cannot be a ground to doubt the veracity of prosecution case. Referring another case law, Bonti versus so-and-so, the learned special PP further submitted that unless the investigating officer is categorically asked as to why there was delay in examination of witness, defense case cannot gain any advantage therefrom. On careful consideration of the submission of learned advocate of both sides, in the light of established dictum of law, we find substance in the submission of the special PP, and the ratios laid down in the said cases fully supported his submission. It is a fact that PW3 did not state before the IO the names of the accused which he named in the court, and the FIR being the manager of the TIOC Tea Garden, who was in a state of shock and horror as the whole occurrence took place before his own eyes, where the doctor who was his employee lost his life in the hand of the employees. This finding, Your Lordship, cannot be found from the, cannot be said to be from the evidence, Your Lordship, that he was in shock, Your Lordship. It is natural that due to shock and horror, he did not dare to name the accused who took life of the doctor in his presence. His life, his career, his business, his views are everything involved in the said garden, In such a perplexed situation, she might not dare to go against the employees of his tea garden. Therefore, in view of the law laid down in so and so, the evidence of PWD cannot be deficient. We also find from cross-examination of IO that he examined PW3 on 31/8/2019 itself, and as such, the submission of the learned defense counsel is found to be devoid of any force, and accordingly, same stands repudiated. PW3 has identified as many as 12 accused in the court and named them, and it is elicited in his cross-examination that he has clearly seen accused Sanjay Rajwar, Sanjeev Rajwar, Suresh Rajwar, and Arun Maji assaulting the Deven Dutta on the relevant day, and that he knows the accused persons by their face. We also find from the cross-examination that he did not state the names of the accused before the IO, and he was not asked for, therefore the defense side cannot take the benefits of the same. Now, your lordship, IO will ask, then I will name the accused. That is not how investigation is to be carried out, your lordship. If he knows, he will have to disclose, your lordship. Thus, we find from the evidence of PW3 the complicity of accused Ajoy Maji, Manoj Maji, Anil Maji, Deepak Rajwar, Deveswar Rajwar, Suresh Rajwar, Deveswar Rajwar, Sanjeev Rajwar, Sanjoy Rajwar, Rinku Maji, Bolin Rajwar, and Sanju Maji. Though he has named 30 accused in the affair, he could not identify rest of the accused. It is a fact that there are two Sanjoy Rajwar here in this case, and it is not clear from his evidence which one he has implicated, but this is not a ground to discard his testimony, and the same also caused no dent to the prosecution version, as the other prosecution witnesses established the role of each Sanjay Rajwar beyond doubt. We find the contradiction so pointed out by the defense side in the version of this witness failed to cast any doubt about the veracity of his version. Probative value of his evidence remained unshaken in his cross-examination. His evidence lends unstinting support to the prosecution case. The affair exhibit 2 also lends assurance to the same. On critical analysis and evaluation of his evidence with the yardstick of probability, its intrinsic worth and animus of the witness, we find that same worth believing and accordingly accept the same. His evidence finds corroboration from the evidence of Assistant Muktajyoti Borua, Somen Kundu, Kollanjit Borua, Welfare Officer Jivon Kurmi. The evidence of Muktajyoti Borua reveals that on the date of occurrence at around 4:08 p.m., while he was in hospital bungalow, Manoj Gogoi, official bungalow, Sri Manoj Gogoi, the state manager, called him to the Garden Hospital immediately. Accordingly, he rushed to the Garden Hospital and reached there at around 4:20 p.m. and there he saw 50-60 people shouting outside the Garden Hospital. In the hospital gate, he met Jivon Kurmi, welfare officer, and inquired from him what was happening there. In turn, Jivon Kurmi told him that Deven Dutta was assaulted and he was also chased out from the Garden Hospital by few workers. He also told that Sri Manoj Gogoi, manager, is inside the doctor's chamber. Then he went inside the chamber of Dr. Deven Dutta. There he found 30-40 persons surrounding Deven Dutta. Sri Manoj Gogoi and the persons present there were raising hue and cry. And though Sri Manoj Gogoi was trying to pacify them, no one was listening to him. After 3-4 minutes, more people entered into doctor's chambers, though through both front and back doors of the chamber, and he, along with one staff named Prakash Rajwar, blocked the back door of the chamber in order to prevent further entry of other people inside the chamber. Then suddenly the mob of 30-40 persons who were already present inside the chamber, along with the newly entered persons, started assaulting Dr. Deven Dutta by pushing away Manoj Gogoi. Then someone called police, and after 15-20 minutes, 4-5 police personnel arrived there and entered into doctor's chamber. Then the mob present inside the doctor's chamber became more violent. They pushed 2-3 police personnel and they also stopped the police personnel from doing their duty. After a few minutes, more police force came and circle officer arrived there. With the presence of more police personnel, they could vacate the doctor's chambers by moving out the crowd. His evidence also reveals that by that time, condition of Dr. Deven Dutta was very bad and he was punched in his face. He also noticed blood on the floor just below his chair where he was sitting. Then one police officer folded his trouser, which he was wearing, and then he could see one cut mark on right thigh of Deven Dutta, where from the blood was oozing out. In order to stop bleeding from the cut portion, Dr. Deven Dutta, one police staff, with the help of a saline pipe, tied the cut portion. This and Sri Manoj Gogoi went outside and requested the crowd to allow taking Dr. Deven Dutta out of medical attention, but no one listened to him. Rather, they were shouting that Deven Dutta has to die here. Only after a few minutes, more police force came to Tiok Tea Garden Hospital, and with the help of circle officer, they could finally manage to take out Dr. Deven Dutta and dead body of Samara Majid to the back door of the chamber. And then taken in a police vehicle. It also reveals that prior to taking Dr. Deven Dutta in the police vehicle, 108 ambulance arrived at the garden hospital, but the crowd mob did not allow the ambulance to come inside. They also threatened the driver of the 108 ambulance and chased them away. His evidence further reveals that after evacuation of Dr. Deven Dutta, as per direction of the Manoj Gogoi manager, he stayed back at the garden hospital itself in order to find out the names of the persons present in the crowd and to ascertain why the incident had taken place. Then, with the help of few staffs, namely Prakash Rajwar, welfare officer Jibon Kurmi, and dresser Subhas Rajwar, as well as other staffs, he could gather the names of the persons present in the mob. Later on, he learned from Manoj Gogoi that Deven Dutta had expired. Then around 9:15 p.m., Manoj Gogoi came back to his office in Tea Garden from Jorhat. By that time, he has drafted one FIR as per the instruction of Manoj Gogoi manager and later correction. Manoj Gogoi later and after correction, Manoj Gogoi put his signature thereon as informant. Thereafter, he went to Tiok police station and lodged the FIR there. He confirmed the FIR in the court. His evidence also reveals that in the FIR, he had mentioned the names of 30 persons and all the accused standing trial now was present at the time of incident. Out of them, he could recognize and identify accused Sanjoy Rajwar, son of late Babu Rajwar, Ajoy Maji, Deepak Rajwar, Suresh Rajwar, Deveswar Rajwar, son of late Jugeshwar Rajwar, and he saw them assaulting Dr. Deven Dutta. And apart from them, Sri Misilal Maji, Jabra, and Sri Sanju Maji were also present inside Dr. chamber. He saw them shouting and raising hue and cry, but he did not see them assaulting Dr. Deven Dutta. Rest of the accused persons were also present inside Dr. chamber, engaging in pushing and shoving and raising human crisis. Evidence also reveals that on inquiry from his office staffs and few workers as well as from Somen Kundu, he came to know that the whole incident had taken place due to instigation of accused Sri Manoj Maji, who was a member of Acha. He also came to know from his office staff and few workers that it was accused Manoj Maji.
Manoj is also one of the accused. He has been
But in
sentenced
life. And interestingly, Your Lordship, this Manoj Maji, all others named, Your Lordship, he was not named by Your Lordship, these protected witnesses. No reference to this man, Your Lordship, by the protected witnesses, Your Lordship. But all others says he was instigating, Your Lordship. That's a mystery, Your Lordship. It is elicited in his cross-examination and also confirmed through IO, PW 56, that this witness did not state to him that he, along with one staff named Prakash Rajwar, blocked the back door of the chamber and that the crowd present inside Dr. chamber pushed 2-3 police personnel and they also stopped the police personnel from doing their duty, and that 30-40 persons who were already present inside the chamber started assaulting Dr. Deven Dutta by pushing away Sri Manoj Gogoi, and that condition of Dr. Deven Dutta was very bad as was punched in his face. He of course admitted that he did not name the accused persons, namely Sanjoy Rajwar, son of late Babu Rajwar, Ajoy Maji, Deepak Rajwar, Suresh Rajwar, Deveswar Rajwar, son of late Rogeshwar Rajwar, about assaulting Dr. Deven Dutta by them specifically, but he has stated about assaulting Deven Dutta by persons present inside the doctor's chamber. He also admitted that he did not name Sanju Maji and Misilal and Jabra before the police about their shouting and raising hue and cry specifically. Admittedly, also he did not state before the police that he also came to know from his office staff and few workers that it was accused Manoj Maji who compelled Dr. Deven Dutta to be seated at his chamber, preventing him from coming out as he came to know about the same much after the incident. Except this, the defense side could elicit nothing tangible to demolish the version, Your Lordship. The names are stated for the first time. The allegations are come for the first time before the court, Your Lordship. What more can need to be, Your Lordship, elicited? In his written argument, the learned defense counsel has assailed the evidence of this witness on the ground that he did not name any person before the IO, though he named 7 accused in the court, and that he gathered the names of accused from one Prakash Rajwar, welfare officer Jibon Kurmi, PW 52, and Dresser Subhas Rajwar, PW 25, as well from others. Yet the prosecution has not examined Prakash Rajwar as witness here in this case, and admittably PW 52 did not see the accused person assaulting Dr. Deven Dutta. Therefore, it is contended not to place reliance upon the same. It is a fact that prosecution side has not examined Prakash Rajwar as witness here in the case, but non-examination of Prakash Rajwar would have no bearing upon the veracity of evidence of witnesses of this witness, in as much as he gathered the names of the accused from other staffs. But who are those other staffs that has not been named, Your Lordship? a general statement that these other stuff, Your Lordship. Also, apart from Prakash Rajwar, it also a fact that he did not state the name of any accused before the IO which he has mentioned in the court, but in view of the law laid down in Vikas Chaudhary versus State of Assam, as discussed in the foregoing para, we are inclined to ignore the same. Now, Vikas Chaudhary is in respect of not naming in the FIR, Your Lordship, the person. Not about not naming in the 161, but by linking this with Vikas Chaudhary, he has held that it cannot be ignored. These other contradictions so brought on record and proved and also admitted by witnesses are not on material point. As such, the same failed spell in veracity of his version. On careful analysis and evaluation of his evidence by applying the well-recognized test of basic human probabilities, we find the same clear, cogent, and trustworthy, and we find no ground to disbelieve the same, which lends corroboration to the prosecution witness. The evidence of Sri Somen Kundu reveals that on 31/8/2019 at around 4 p.m., he went to Tiok Tea Estate Factory, and there he got information from Gate Chokidar that some chaos was going on in Tea Garden Hospital. Therefore, once Sri Ajoy Bapi informed him that doctor of the hospital has been assaulted, then he went towards the Garden Hospital. He could see a huge crowd in front of the hospital. He then went into the crowd and asked the mob what had happened, and he could hear the noise of breaking glass and banging of door coming from the doctor's chamber. Then on inquiry, he came to know from the mob that the estate manager Sri Manoj Gogoi and the factory assistant Muktajuti Borua are inside the chamber. Thereafter, along with RD manager Kullanjuti Borua, he went to the Thana to report, and at there they were informed by the officer in charge of Tiok police stations that they have already got the information and forces have been deployed and are on the way. Thereafter, he returned to the hospital and went inside doctor's chambers there, and he found mob chanting slogans in Assamese language that this doctor should die and we will not let him go. He then found the police personnel with towel pressing the Dr. Deben Dotto, right thigh and blood, as well blood was all around that on the floor. The Deben Dotto was in subconscious state, and he could identify him and told him that so far I know my femoral artery has been cut, call the ambulance or I will die. He also found the doctor brutally assaulted on his right eye, was blackened, and he was not in a position to hold his hand, rather it was hanging on both sides. Then he asked his office staff, Debojyoti Borua, to call the 108 ambulance, but he found the ambulance already on the gate, and when he moved out of the chamber of Dr. Deben Dotto to escort the ambulance to the backside, because in front of it was full of mob, and then the mob moved from the front of the doctor's chamber towards the ambulance. Then they asked the ambulance driver to leave the hospital premises. To his instruction, they came backside, and when the door was open, the mob came at the backside of the door of the ambulance, banged it, and the ambulance was surrounded by the mob, chanting that the doctor will not be allowed to go for treatment. We want him to die out here. Thereafter, being afraid of, the driver went out along with the ambulance. Very soon, CRPF arrived at there, and the mob in front of the chamber of Dr. Deben Dotto was moved back down the veranda, and the estate manager Manoj Gogoi has requested the mob to let the doctor to go for treatment. However, the mob was adamant and was chanting the same slogan. As stated above, thereafter CRPF and police personnel had taken Dr. Deben Dotto towards Jorhat Medical College and Hospital in police vehicle. Thereafter, police collected articles from the place of occurrence. Later on, he came to know that Dr. Deben Dotto succumbed to his injuries. His evidence was also reveals that when he returned from Thana and was going to the chamber of Dr. Deben Dotto, he saw accused Manoj Maji outside the chamber addressing 8-10 people, that the doctor should have been removed long before by the management, and that they have given application to the manager to remove him. He identified accused Manoj Maji in the court. His evidence also reveals that mob he could identify accused Kalang Maji, Ratul Rajwar, Kartik Bhumi, Sanju Maji, and he identified them in the court, and they have shut the door of the ambulance and obstructed the ambulance from taking the doctor to the hospital for medical treatment. Rest of the accused persons present in the court were identified by other staff and state managers from the video footage, as well as from the staff who were present inside the hospital during the time of assault upon Dr. Deben Dotto. They were involved in the incident of assault upon Dr. Deben Dotto. Cross-examination of this witness reveals that he did state before the IO that he do not know about the persons who were involved in assaulting Dr. Deben Dotto. This was very specific, Your Lordship. And that he did not see the accused person assaulting the doctor. It is also elicited, though he identified 4 accused persons other than Manoj Majhi, he do not know their names, and he was called to Jorhat police station to identify the accused person, but he was not exposed to them for security reason. It is also elicited that he did not state before the police that accused Sri Manoj Majhi was outside the chamber addressing 8-10 people, but failed to get the same confirmed to IO, and as such it cannot be placed into service. Now, Your Lordship, he admitted this. Why should I need to confirm it through IO, Your Lordship? He said it is also elicited that he did not state before the police that accused Sri Manoj Majhi was outside the chamber addressing 8-10 people, but failed to get the same confirmed to IO, and as such it cannot be placed into service. It is confirmed that this witness stated before the police before him that he has. It is confirmed that this witness stated before him that he heard chanting in Assamese language. The doctor will not be allowed to go for treatment, and we want him to die out here. Thus, it appears that the witness identified Kalang Majhi, Ratul Rajwar, Sri Kartik Bhumi, Sanju Majhi, who have shut the door of the ambulance and obstructed the ambulance from taking the door to the hospital for medical treatment. He also identified accused Manoj Majhi, who was addressing 8-10 people. Though he could not identify rest of the accused by name, yet according to him, they also present inside the hospital during time of assault upon Dr. Deven Dotto. They were involved in the incident of assault upon Deven Dotto. It is also submitted by the learned defense counsel that the witness is a colleague of the complainant and assistant manager of Tiok Tea Garden. As such, he is an interested witness here in this case, and therefore his evidence cannot be relied upon. But on a dispassionate scrutiny of the evidence of this witness, we find ring of truth in the same, and accordingly we accept the same. Thus, we find this witness also rent supports to the prosecution person.
So it's not the truthfulness, it is the evidentiary value.
Lordship,
He is true, he appears to be truthful,
Lord,
but how much evidence can be taken into consideration?
Lordship. That is your Lordship. And in view of what your Lordship, this is for the first time he has made this statement before the court before. No. No. I think that is
How
like
do you react to this, madam? Paragraph 40 to 52. Requirement of a confirmation by the IO?
Not required.
Not at all required.
DK Mishra says that once he
Yeah,
says,
even otherwise, just as a layman, as a practical, not even in knowing the niceties of law.
that this is a wrong. That is not, DK Mishra is very clear.
53 not required, your Lordship. He has not seen the incident, your Lordship. 54, your Lordship. Para 54. The evidence of Jibon Kurmi, welfare officer of Tiok Tea Estate, reveals that on 31/8/2019 at around 4 p.m. while he was in his official quarter at Tiok Tea Estate, then Sri Debojyoti Borua, office staff informed him over telephone that Dr. Deven Dotto was being assaulted by some of the laborers at Tiok Tea Garden Hospital. He then rushed towards the hospital, and there he found many people in the veranda of the hospital and also in the chamber of Deven Dotto. And while he was trying to enter into the hospital, then someone pushed him in the veranda and he fell down on the ground and sustained injury over his hand and back. Then he noticed the Manoj Gogoi, senior manager, and the assistant manager Muktajyoti Borua entering into the hospital campus. There were about 100 and 150 people inside the hospital and in the veranda. Then along with Satyajit Hazarika, he went to Tiok FRU and took medical treatment. Then at about 7 o'clock, he came to know from Sri Muktajyoti Borua and Sri Somen Kundu about the death of Dr. Deven Dotto at Jorhat Medical College Hospital. His evidence also reveals that at the time of his reaching the veranda of the Tiok Tea Garden Hospital, some people were assaulting the doctor, but he has not seen the person who have assaulted the doctor at the relevant point of time. His evidence also reveals that he has seen the accused standing trial now in the veranda of the Tiok Tea Estate Garden Hospital and also inside the hospital compound. And he heard assaulting Dr. Deven Dotto by the people inside his chamber, but he did not witness the incident of assault. Cross-examination of this witness reveals that he has not remembered whether he has stated the names of the persons to the IO who have assaulted him on the relevant day of occurrence. It is also elicited that he has seen Shivsaran Mahali in the veranda of the hospital, and he has not seen Sri Shivamali. He has seen Pritam Majhi in the veranda of the hospital, but he does not know his name. He has also seen accused so-and-so so and so. These are the names, Your Lordship, in the veranda of the hospital. He has accused Upen Bhumi's Ratul Rajwar near door of the chamber, doctor of hospital, and he has seen Sanjoy Rajwar, Sanjeev Rajwar, Suresh Rajwar in front of the door of the room of doctor. He has not seen the rest of the accused. It is also elicited that he reached the hospital after half an hour of the beginning of the incident, and he was there for about half an hour to 50 minutes. Thus, we find from the evidence of witness that he has seen this person at the veranda, also in front of Dr. Sember, though he had not seen them assaulting doctor. The learned defense counsel assailed the evidence of PW 52 on the ground that he did not see the person who had assaulted Deven Dutta, but it is not the prosecution that this witness has been seen assaulting doctor by the accused. Rather, it is the defense case that witness has seen 23 accused name above in the place of occurrence, and he identified them in court. In court. In the above place of occurrence, he identified in court. We find element of truth in his version, which lends support to the prosecution version. We accept the same. Accordingly, he faced the wrath of the accused person while he tried to enter into the hospital. PW 32, Sri Manoj Das, 36, Gopal, these are all Your Lordship protected witnesses. Gopal Bora, PW 37, Rupam Soikia, 38, Pawan Gaur, PW 39, Jivan Tati, PW Raju Barik, Pawan Sahu, are the eyewitness to the occurrence, and these 7 witnesses also lend unstinting support to the prosecution case. The evidence of PW 32 reveals that on 31/8/2019, which was a Saturday at around 3:10 p.m., he went on to tea stall situated at Tiok Bagan Tiniali to have a cup of tea. On his way, he saw a huge crowd in front of Tiok Tea Garden Hospital. He then went there and saw some members of the crowd pushing and pulling welfare officer. He could identify and saw accused Suresh Rajwar among others pushing and pulling the said welfare officer. He then tried to resist them. Then he went cry inside the doctor's chambers. He went there and saw Dr. Deven Dutta was being surrounded by 60-70 persons in the chamber, and they were shouting and saying that doctor should be traced. He could identify and saw accused so and so, and they were shouting and demanding that doctors should be traced and assaulted. His evidence also reveals that meanwhile some members of the group who were inside the doctor's chambers at the time started assaulting Dr. Deven Dutta by giving blows. He could identify the saw accused persons, namely Ajoy Maji, so and so, giving blows to Deven Dutta. His evidence also reveals that the accused Shivam Mahali kicked the doctor from his side, and then he and deputy manager, whose name he could not recollect, and Manoj Gogoi, board manager, tried to restrain the persons from pressing and assaulting Dr. Deven Dutta, but they did not listen to them. Thereafter, police personnel arrived there, and then some persons become more excited, and he saw and identified Sanjoy Rajwar, son of Babu Rajwar, Ratul Rajwar, and Rinku Maji breaking the glass panes of doors and windows by giving blows, and they sustained cut injuries in their hands. Further, he saw and identified accused person, namely Bablu Rajwar, Sivasaran Mahali, and Sri Rahul Rajwar were pulling and pushing the police personnel. He has seen all these named accused persons in court today. His evidence also reveals that he saw Dr. Deven Dutta bleeding from his thigh position of his leg profusely, and also he saw injuries on his face. Then, on arrival of more police personnel, situation could be controlled, and Dr. Deven Dutta as well as dead body of one Samara Maji was taken in a vehicle by the police to hospital. His evidence also reveals that at the time of incident, he saw Sanjoy Maji, Bolin Rajwar, Gurudev Maji, Arun Maji, Pritam Maji, Anil Maji, Rinku Maji, Misilal Maji, and Elias Jabra standing inside doctor's chamber. One of them, Sri Arun Maji, Pritam Maji, Elias Soikia, and Anil Maji accompanied Samara Maji. Later on, he came to know Dr. Deven Dutta died at the hospital. His evidence also reveals that police got his statement recorded in the court at Jorhat, where he put thumb impression over the same. Cross-examination of this witness reveals that he knows the accused persons prior to the incident. It is also elicited and proved through IO that he did not state that accused Suresh Rajwar pushing and pulling the welfare officer, and that he, deputy manager, and Manoj Gogoi, board manager, tried to restrain the persons from pressing and assaulting Dr. Deven Dutta, but they did not listen to them, and that the accused Bablu Rajwar, Sivasaran Mahali, and Sri Rahul Rajwar were pulling and pushing police personnel. The learned defense counsel in his written argument has assailed the evidence of PW 33 on the ground that he was tutored by police by keeping him for 7 days at the police station along with other 6 witnesses who were protected under Clause 7E of the Witness Protection Scheme. It is also submitted that there are many contradictions in his version with his previous statements under 161 as well as under 164 CRPC, but having considered the submission in light of facts and circumstances on the record, we find that contradictions so brought on record and proved by defense side appears to be insignificant and same are not material point. Besides, the defense side could not prove that he was tutored by police and even no suggestion was put to him in this regard. Nothing tangible could also be elicited in cross-examination to discredit his version. Thus, we find witness also lends corroboration to the prosecution version. His presence at the place of occurrence at the relevant time and his explanation for being present at the that he had seen the occurrence is not dispute. His statement under section 164 CRPC is also consistent with his evidence for the court in material particulars, wherein vividly described the role played by each and accused person. He has explained as to why he was there, and the same is not disputed by the defense. We find worth believing. We find his evidence clear, cogent, credible, trustworthy, and reliable. Therefore, we are inclined to accept the same. Then Gopal Bora. He is the person, Your Lordship, who has named the Sanjay Rajwar as the person who stabbed the disease, Your Lord.
You said that you'd elaborate on the aspect of protection witness in
Lord.
2018.
Lord.
Would you like to do now or after reading of the?
I read it, Your
Okay,
Lordship. Then.
Then you need not read the entire thing,
Lordship.
whatever is relevant in the.
Lordship, here,
judgment.
Your Lordship, I only want to place Your Lordship so far as para 59 is concerned.
Hmm.
That Your Lordship, he says, Your Lordship, this is, in my view, is important. When he entered the place, Your Lordship, room, Your Lordship, he
Who?
found the
Sanjay.
PW 36, Gopal
Okay.
Bora.
Hmm.
When he entered the doctor's room, Your Lordship, he found the manager, PW3, as well as the few police personnel present there. And thereafter, he saw that this person, Sanjay, Your Lordship, has assaulted, stabbed the deceased, Your Lordship. Now, very interestingly, Your Lordship, neither the police personnel, Your Lordship, nor the war manager has named it, Your Lordship. Now, all of them are there, Your Lordship, all along with one Prakash Rajwar. He was not even brought, Your Lordship. Now,
Prakash was not examined.
not examined, Your Lordship. Now, Your Lordship, these two persons, Your Lordship, this is in my submission, the humble submission, Your Lordship, the fact what he has seen, Your Lordship, except Your Lordship, him and PW 37, who is again a protected witness, no one has seen Sanjay Rajwar, Your Lordship, assaulting the doctor, Your Lordship. And war manager PW3, then this Muktajyoti Borua, PW 28, and the few police personnel, Your Lordship. I have, Your Lordship, already read those statements, Your Lordship. They were there, but they are not implicating this particular person, Your Lordship. That is, in my humble submission, is that's why, Your Lordship, the manner in which these persons, Your Lordship, brought in as a protected witness creates doubt about veracity of their statements. Had it been corroborated by other accused persons, other witnesses, Your Lordship, who are present at the relevant point of time,
Who were present police persons?
police persons, PW3,
PW3 is who?
PW28,
Who is PW3?
PW3 is the informant, Your Lordship, Manoj Gogoi,
The manager.
manager, and Muktajyoti Borua, he is PW28, who had written this FIR, Your Lordship, initially, Your Lordship. And Prakash Rajwar not even examined, Your Lordship. He could have been a star witness for them, Your Lordship. Having seen entire witness, they have withheld him, Your Lordship.
Yes.
Now, Your Lordship, therefore, Your Lordship, till Your Lordship, I will not read it, Your Lordship. This same vein, Your Lordship, they have, Your Lordship, what they have stated in 164, they have stated this. But only thing, Your Lordship, my point will be, Your Lordship, the manner in which they are brought in as a protected witness, violating the mandate of the scheme,
Yes, kindly highlight that.
that Your Lordship may kindly take up. Go ahead here. I would statement to you. This is your lordship team, your lordship.
Hmm.
Now your lordship they have said, your lordship, application was under 7E, your lordship. Clause 7E, your lordship. Page 6, bottom, your lordship.
7.
E. Concealment of identity of the witness by referring to him or her with the changed name or alpha.
Yes.
Now, your lordship, part 3, clause 9.
Yes.
During the course of investigation or trial of any offense, an application for seeking identity protection can be filed in the prescribed form before the competent authority through its member secretary. Upon receipt of the application, the member secretary of the competent authority shall call for a threat analysis report. The competent authority shall examine the witnesses or his family members or any other person it deemed fit to ascertain whether there is necessity to pass an identity protection order. That your lordship will kindly note that there will have to be a threat perception report, your lordship. During the course of hearing of the application, the identity of the witnesses shall not be revealed to any other person which is likely to lead to the witness identification. The competent authority can thereafter dispose of the application as per material available on record. Once an order for protection of identity of witnesses passed by the competent authority, it shall be responsibility of the witness protection cell to ensure identity of such witnesses, his or her family members, including name, parentage, occupation, address, digital footprints are fully protected. As long as the identity of any witness is protected under any order of the competent authority, the witness protection cell will provide details of persons who can be identified. Then your lordship contacted your lordship. Then your lordship, change of identity, relocation of witnesses. Now your lordship will kindly.
Now, are you on the aspect of how these witnesses were made protected witnesses? Or are you on the aspect regarding their deposition in the court that the procedure which is required to be followed,
Lord,
that has been violated?
since their
See,
procedure.
there will be two aspects. First, you have just made a hint on the threat perception report.
Lord,
That was not there.
that was not there.
But that is one part
Lord,
on whether they could have been regarded as protected witness
Lord.
at all. Even if you are successful in that part, their evidence, are you assailing their evidence? in
Your
the court?
lordship, that
That
your
will be
lordship,
more important.
that no, your lordship, ultimately your lordship, if that is not there, none of the witnesses, your lordship, these protected witnesses, except one probably your lordship has said that they are under threat, your lordship. One says that I, on my own, went to the police station. That means, your lordship, there is no threat as such, your lordship. In spite of that, that has been done, your lordship. In the process, your lordship, why this procedure has been there, your lordship? This is because, your lordship, the moment one person is protected and his name is changed, we don't get his identity, we don't know about his credentials, your lordship. To put a person, ask some questions on the credentials of that particular person, your lordship, we have to know his background. Now he may be a person, your lordship, these persons, your lordship, who was there in the offense, when offense is committed, your lordship. We could have, had we seen them, your lordship, in the dock and identify them, then we could have asked certain questions of their credential, your lordship. That way we got
No,
prejudice.
see, protection witness the scheme under a situation of this nature,
Lordship,
where the witnesses are mainly of that locality.
lordship,
Only their names have been changed,
lordship.
but their identity, when you see them in the dock, that will not change.
No, your lordship.
It's not under some veil that they are.
No, dock, he was not, your lordship, put in, bring to the dock. The moment it is protected witness, your lordship, we don't know about him.
How do you cross-examine?
That, your lordship, without seeing his face, your lordship, I will have to cross-examine.
Is there a veil kind of a thing?
Yes, your lordship, that's what, in a certain.
How
no,
is it done?
But your lordship, we cannot see his face, your lordship. That's what, your lordship, in all, even in NIA cases also, your lordship, the persons were not allowed, your lordship.
Their depositions were taken in camera.
Lordship, and your lordship, identity not revealed, your lordship. Face we cannot. Now we don't know who he is, your lord. That's why it's all about protected. Unless your lordship, he can be bring into the talk, your lordship. There's no question of protecting this witness, your lordship.
That is what we are trying to understand.
Lordship,
Suppose in a case, one witness who is not known to the locality,
lordship.
he by chance, he or she witnesses something, but there is an apprehension that if I come as a witness, I may have a threat. So that witness who is not known, but these witnesses, even from their voice, you will not be able to identify or what.
Lordship, voice, your lordship, that, your lordship, it's a very,
That is
very
slightly,
difficult
slightly difficult.
aspect, your lordship, from voice, your lordship. And in fact, your lordship, some of the
How many protected witnesses were
Seven,
there?
your lord.
Seven.
seven. Lord. Now, your lordship, why I am stressing on this, your lordship, when a procedure is there and you are applying on the basis of that procedure, you will have to go by that. Unless you go by that, and your lordship will kindly see why I am
That is
stressing.
what we are trying to understand,
Lord,
that there are two parts.
Lord,
Whether, how do you have you identified them to be protected witnesses?
Lord,
Or given them the status of protected witnesses. Then the second part is their deposition in the, whether it was in accordance with law. Now, if you are saying that these are intrinsically connected, the moment you give them the status of protected witness, then they are on different footing. You may not be in that position to cross-examine them
effectively,
vis-a-vis any other witness.
Lord.
Okay.
And secondly, your lordship will kindly see, this will have to be seen along with your lordship, the fact that they were kept for 7 days in the Jorhat police station, your lordship. Before, your lordship, their statements under 164 is recorded, your lordship. That's why, your lordship, we have been arguing, your lordship, that they were tutored, your lordship. And interestingly, your lordship, except these witnesses, your lordship, no one has in fact named the accused persons before the police, your lord, that they have assaulted it, your lord. All are improvements, your lord. That's why it creates serious doubt about the veracity and genuineness of the evidence of these 7 witnesses, your lordship. And in fact, although it is a scheme, your lordship, yeah, this is also put it. Even do not take it. In 2019-14 SCC 615, your lordship,
Name?
Mahendra Chawla and others versus Union of India and others. Your lordship, I will show that.
You had just submitted that under 142.
Your
it has been
lordship, that is your lordship, it is there.
Unless and until
A
statute is.
statutory mechanism come. I have seen find this in early morning, your lordship. I'll show that, your lordship. That's in a paragraph.
Which one?
This one, your lordship.
Regarding what?
Regarding that, this is a law so far as under Article 1.
It is there, we have seen this.
Lord,
It was circulated.
Lord, since it is law, your lordship, they will have to abide by the procedure laid down in this, your lord. And it's, your lordship, it is a very serious issue, your lordship.
We come to pay para 35.
Lord. Para 35.
Then you read 36(2).
Lord. Mahendra Chawla. One thing which emerges from the aforesaid discussion is that there is a paramount need to have witness protection from and all the prayers in this criminal justice considered. At the same time, no such legislation is brought about. There are the considerations which have influenced the court to have a holistic regime of witness protection. It should be considered as law under Article 1 Constitution till this suitable law is framed.
Then 36(2).
Lord, the
And
Union of
36(3).
India as well as the states and the Union territories shall enforce the Witness Protection Scheme 2018 in letter and spirit.
And
Letter
it shall
and
be
spirit.
the law under 41, 42.
Two of the Constitution till the enactment. So, Your Lordship, they will have, it is a case, Your Lordship, where Your Lordship, therefore, in my humble submission, Your Lordship, that is why, Your Lordship, I am stressing on this particular witness protection scheme, Your Lordship, and Your Lordship may kindly see the, I am reading it, Your Lordship, evidence of the investigating officer. He says, thereafter, I had made a prayer before on 4/9/2019. I have arrested accused person, namely so and so and so and so. Thereafter, I have made a prayer before the court for protection of some of the witnesses under witness protection scheme. An interim order was passed by the court to conceal the identity of said witnesses under witness protection scheme. On 5/9/2019, I have recorded the statement. There is no reference, Your Lordship, about Your Lordship any other matter.
That threat perception report was not there
Not there. Not there. Apparently, Your Lordship, it is clear from there.
for all the 7.
All this on the same day that was passed through. And none of the, except one, Your Lordship, I will show that, Your Lordship, which one. Then, Your Lordship, none of them has said that there is any threat to them, Your Lordship. And one actually says that I went on my own to the police station. Now, if he had threat, Your Lordship, I will show that, Your Lordship. Then, Your Lordship, 36 and 37 has, Your Lordship, made specific statements about the assault made by the Sanjay Rajwari, Your Lordship. Then, Your Lordship, may kindly come to para 75, Your Lordship. Lordship, I'm taking somewhat.
Yes, yes, please.
Para 75, Your Lordship. This is crucial witness, Your Lordship, to Lesser Marty, EW 44.
Yes.
The evidence of the Duleswar Mazi PW 44 reveals that on 31/8/2019, while he was in the office of Tiok Police State, he got information from the Manoj Rajak, Chokidar of the hospital, that about 3:30 p.m. some incident had taken place in Tiok Tea Garden Hospital. He then went there and he found about 40% in the veranda of the hospital and they were shouting. He also saw the garden manager Sri Manoj Gogoi entering into the hospital compound and he also immediately followed him. Then entering into the compound of hospital, he found that around 30-40 persons were assaulting the doctor who was sitting on a chair in his chamber. And he found accused one, Sri Sanjeev Rajwar, these are the person's name, assaulting Dr. Deven Dotto in his chamber with fists and blows. 20% assaulting Dr. Your Lordship. Will kindly note that, Your Lordship. And 6 injuries. Out of these, Your Lordship, 5 were contusions. He also witnessed the garden manager, Sri Manoj Gogoi, deputy manager Muktajyoti Borua, and staff Sri Bijoy Rajwar trying to save the doctor from the clutches of the accused named above. Then he also tried to pacify the persons present in the doctor's chamber. At that time, somebody had broken the window panes of the garden hospital. His evidence also reveals that he noticed some of the persons present outside the hospital compound shouting to the assault doctor. They also caused mischief in the furniture of the hospital. Then someone from there called the 108 ambulance, and when the ambulance arrived at there, the accused persons, namely Bablu Rajwar and Milan Rajwar, chased away the 108 ambulance. They again tried to return to the doctor's room and started to assault the doctor. Rest of the accused person whom he has named in the court also followed Bablu and Milon to chase away the 108 ambulance from the hospital campus. Thereafter, all of them again went towards the doctor's chambers and started assaulting the doctor. His evidence also reveals that when police arrived at there and tried to control the situation, then some of the accused persons shouted to assault the police personnel. He also went near the 108 ambulance, and when he returned to the hospital, he found oozing out of blood from one of the leg of Deven Dotto. After some time, more police personnel arrived at Tiokti Garden Hospital. Then the situation comes under control. Thereafter, he left for his office. In the meantime, doctor was shifted to JMCH at about 5:30 p.m. Later on, he came to know that Dr. Deven Dotto succumbed to his injuries at 7:30 p.m. His evidence further reveals that on the next day of occurrence, police recorded his statement by calling him to the police station. Then they have shown him some video footages of the incident. Your Lordship will kindly
Next
note.
day.
Next day, Your Lordship. The video footages of the incident. However, he cannot say where from police collected the opposite video footage, but he has seen some of the people recording video footage of the incident at the place of occurrence. Then police asked to identify the accused persons, and accordingly he identified them having seen the video footage, and thereafter police downloaded some of the clips of the video and taken printout of the same, and also taken his signature thereon. He confirmed material exhibit 53, a compact disc marked as video number 1, and on playing the same in the court in desktop computer, he could see assaulting the doctor by accused Sri Ajoy Maji. Manoj Maji was standing nearby to the accused Sri Ajoy Maji. On playing the video, he could see that accused Sanjoy Rajwar, Rinku Maji, Suresh Rajwar, Rameswar Bhumis, Bablu Rajwar, Kalang Maji, Sanjeev Rajwar, Deveswar Rajwar, Kartik Bhumis, Rahul Rajwar, Sitsaran Mahali were scuffling with the police personnel, and Sibo Mahali, Bijit Mahali, and Deepak Raj were assaulting the doctor. Sri Manoj Gogoi, garden manager, and Mukul Rajwar were trying to save the doctor. He could see oozing out of blood from the head of the Deven Dotto. He could also see accused Sanjoy Rajwar, son of Bablu Rajwar, breaking the glasses and windows. Then, Your Lordship, please photograph, Your Lordship. Man. Then 79, Your Lordship. It is elicited in the cross-examination of the witness that all the 20 accused persons who he named in his examination sheet have not assaulted the doctor. It is also elicited that he could not identify any of the accused shown in photograph in material exhibit 55, 56, 57, 58, 60, 63, 95, 96, 97, 116, and 122. In material exhibit 66, he could identify Dr. Deven Dotto and manager Manoj Gogoi and Mukul Rajwar, but he could not identify the accused Bijoy Mahali. In material exhibit 89, he could identify the photo of Bablu Rajwar, but he could not identify the accused person. In material exhibit 101, 102, 103, the accused whom he could identify were present in the veranda of the hospital. It is further elicited that material exhibit 104, 105, 106, 107, 108, all the accused were in the veranda of the hospital. He could not identify the other accused who were with accused Ratul Rajwar. In material exhibit 111, he could identify 3 accused, namely Bablu Rajwar, Sanjeev Rajwar, and Sanjeev Maji. And accused Sanju Maji was preventing all the 3 accused persons not to assault the doctor. Your Lordship will kindly note that. So far as
111. Exhibit 111.
111.
Yes, we have read this earlier,
Earlier, Your
166.
Lordship, that is there. It is also elicited that he did not, para 81, he did not state before IO that some of the persons present outside hospital were shouting to assault the doctor and also caused mischief of the furniture of the garden hospital. Accused Sri Babul Rajwar, Milon Rajwar, chased away the 108 ambulance.
This discussion perhaps you can skip because
Lordship.
you have taken us elaborately to the
Lordship, Lordship.
evidence.
He, Your Lordship,
166
Lordship.
of the
Then, Your Lordship,
volume 1. Just a repetition because I have the note 166, the same thing with the repetition. If there is something unique, you can point it out.
no,
Otherwise,
Your
it's
Lordship,
just
what
a-
I am trying to
just a
point out,
repetition.
Your Lordship, that these evidences, Your Lordship, even naming of the persons, Your Lordship, for the first time, Your Lordship, he has not stated
No,
this.
that we have
Yeah.
already- he
Lordship,
has said
recorded.
in 165, 166, I
Lordship.
have not stated before the
Lord.
police. It is a fact that I have not stated.
Lord,
That part he has
Lord.
confirmed.
that's what, Your
That is
Lordship.
what we have just reconfirmed. We
Lord.
just noted the pages.
Lordship, Lordship.
Volume
That's why,
one,
Your
page
Lordship,
165.
this will not be required, Your Lordship, anyway. Then, Your Lordship, Then your lordship may kindly come to para 106, your lordship. This I just
Page,
page 641. We have in fact, your lordship, from the very beginning, your lordship, we have seriously disputed the videos, your lordship, on 2-3 counts, your lordship. First, your lordship, the video that has been, whether the same video has been shown to PW 44, which your lordship, they have, your lordship, seized, your lordship, from the PW 43 and 44 or not, that is not clear, your lordship. PW 44 reading PW statement of PW 44, it becomes clear that he has, your lordship, in fact been shown a video which is identical, the same video from which, your lordship, from same video which was presented before the honorable court, your lordship, shown in the court, your lordship. And but that video apparently cannot be, since, your lordship, they have seized it on 14th, your lordship. Therefore, your lordship, they have not come up, your lordship, a specific evidence that, your lordship, that this is the video which we have seized, your lordship. That is not there at all, your lordship. Now, your lordship, may 106. Here in this case,
just a minute, just a minute. Video, 14. So immediately on the second day, how can the same that will be shown to the witness by the police? The certificate, at least we have to go over the record. Record says 14th you are given the notice to come and give the video, and he is given a certificate on the same day, 14th, it's okay. But this witness, he says that immediately or maybe over a couple of days, these it was shown, and from there I identified. So one of the video actually see, because it could not have been seen. How? Then if it was sealed, it was in the certificate. Even if you do not go to the aspect of whether the computer was certified, the data cable was certified, even where the certification of the mobile phone, even if that is taken to be authentic, it a certified tape has to be shown to the witness. They are shown a tape much before the certification. So whether it will meet the standard of relevant evidence. Yes.
here in this case, the genuineness of the videos and photos printouts taken from the clippings of the said videos have not been disputed by the defense side. This finding, your lordship, is
Page,
page 4641, para 106.
please read.
Here in this case, genuineness of the videos and photo printouts taken from clipping of the said videos have not been disputed by the defense side. That is not correct. Also, from the evidence of your lordship, we have made specific suggestions, your lordship, regarding the genuineness of the video. Your lordship.
Yeah, just let us assume that he did not put any cross-examination or question the cross-examination or no suggestion. But if it does not go through the procedure laid down in the Evidence Act,
Then, your lordship,
can it
will go.
be?
No, your lordship.
Can it be a relevant piece of
No,
evidence?
that is not. That is not. If it is not as per the law, your lordship, evidence act, your lordship. Even your lordship, if
You hearing an appeal, so we can.
your lordship can go into all. Consistent. Then, your lordship, para
Facts
10.
admitted need not be proved. How do you overcome that facts admitted need not be proved? Is it a fact or is it an evidence?
Which one, your lordship?
The requirement of the Evidence Act. Evidence Act. $58.
Lordship.
of the Evidence Act.
Lord. Tax admitted did not be proved.
Now, will it even do away with the procedure laid down in the,
That's probably not pure.
because this is a special kind of an
Lord,
evidence,
Lord.
electronic evidence.
Electronic. And secondly, Your Lordship, from the the oral evidence of the witnesses also, Your Lordship, the kind of discrepancy they showed, Your Lordship. In P.V. Anwar and subsequent judgment by Justice Nariman, Your Lordship, it is very clear why such a rigorous kind of, Your Lordship, protection is given so far as the electronic evidence is concerned. There is a possibility of tampering with this evidence.
Now, if you read the objection reasons of the amendment
Lord,
of 2000,
Lord,
where which 65A and 65B have been brought in, those are elaborately discussed.
Lord,
Because once you regard these as evidence,
Lord,
at the same time you have to give
Lord.
all the safeguards. Otherwise, there will be misuse.
Lord,
Any clippings may be a valid piece
Lord.
of evidence.
Lord.
Why is the need of a certification?
Lord,
And certification is only to make the evidence admissible in
Lord.
evidence. It's not proof.
proof.
You have to still prove
Still
it.
prove
The
it.
burden is not shifted. Burden still there.
Lord,
Onus will be shifted only
Lord.
when you discharge your burden that you have proved it. It's an admissible piece of evidence after the certificate.
Lord. Para 109, Your Lordship, learned court below has dealt with the fingerprints, Your Lordship.
The chance fingerprint.
Chance fingerprint.
Page 644.
Page 644. From 109 to 113, Your Lordship. I will not read it, Your Lordship. No requirement to read it. I only want to place one submission on this, Your Lordship.
Please.
That is, Your Lordship, when fingerprints were collected, Your Lordship, the manner in which these fingerprints were collected, that has not been disclosed, where it is kept, Your Lordship. Then after around 9 days of collection, this, Your Lordship, it was, Your Lordship, collected by the Direct Forensic Department, Your Lordship. Now, Your Lordship, in this process, Your Lordship, how it is collected, and a very interesting, Your Lordship, aspect is there, Your Lordship, so far as collection of the chance fingerprint, Your Lordship. There are statements by the witnesses, Your Lordship, not only Sanjay Mazi, Sanjay Rajwar, Your Lordship. Apart from them, some other persons are also there who has also broken the glasses, Your Lordship. Now, for arriving at the truth, Your Lordship, it is necessary that they eliminate the other possibilities, Your Lordship. Now, in that particular piece of glass, Your Lordship, there may be fingerprints of Sanjay, then there may be fingerprints of Rinku Maji. Now, unless you eliminate others, Your Lordship, how can you only say that this only Sanjay Rajwar's fingerprints are there? That elimination process they have not done, Your Lord. Your Lord. That is an important aspect, Your Lordship, which neither fingerprints expert, the IO has collected that, Your Lord. It is fact that there are certain questions that ought to have been put to the IO regarding his competency about collection of, Your Lordship, the fingerprints. Although he is under the law, he is allowed. Whether he is competent or not, that has not been put. Therefore, I cannot raise this at this point of time, Your Lordship. But the fact remains, Your Lordship, that when it was collected, Your Lordship, the elimination of other fingerprints, existence of other fingerprints has not been ensured, Your Lordship, as revealed from the evidence of the IO, Your Lordship. Secondly, Your Lordship, the manner in which it was kept, when it was sent, who took it, took it to the directorate, that has also not been brought on record by the prosecution, Your Lordship. And in fact, Your Lordship, the Assam Police Manual, Your Lordship, there is specific provisions relating to, Your Lordship, fingerprint expert, Your Lordship.
Part 5.
Lordship, I will show that. Part 4, your lordship.
Which one, which clause?
Clause, your lordship, I am relying on, your lordship, 117. 117 onwards, your lordship. It 117 says duties of the investigating police, use of fingerprint system in investigation. It starts with that, your lordship.
Part 5 or two? He said part 4.
Part 4, your lordship.
Part 4 we
In this book, your lordship, page 11, it starts from page.
Oh, this is a different book. Mr. Waterford, let's have a look at this book and try to find it
Sure.
out.
Approximately.
One one seven.
117.
Yes, please.
Duties of the investigating police, use of fingerprint system in investigation. It starts from there, your lordship. Your lordship will kindly come to 119, your lordship.
Yes.
Search for fingerprints left upon articles, etc. connected with or surrounding the scene of crime. That
Hmm.
is the chance fingerprint. Cases in which research should be made for fingerprints. In committing crimes, culprits often inadvertently leave their finger impressions on article of all description, and it is desirable that every article which might bear such impressions, more especially glass, metal, polish good or lacquer work, should be most carefully examined by a magnifying glass. Torches abandoned by dacoits should always be examined, as good finger impressions are not frequently found on their third surface, while upon bottle sources such impressions are usually clear. It is in burglary cases, finger impressions are often to be found on bamboo mattings near the points of entry or on doorpost. In cases of murder, immediate search should be made for blood-stained finger impression. Article to be sent for examination. When an impression, however faint, is detected, the investigating officer will ascertain whether the article in question have been touched by anyone since occurrence. This is important. If he is satisfied that fingerprints are undoubtedly that of culprit, he should take into his custody either the article or those portions or it is contained the impressions, carefully removing it in the presence of respectable witnesses after putting on it such marks as would make the subsequent identification possible, and should forward it to the special superintendent of police in charge of criminal investigation department for examination by fingerprint bureau. Now, your lordship, the language in which this has been made, your lordship, this, then he should have immediately sent this, your police in charge of the criminal for examination of the fingerprint bureau. If, however, in the nature of article is such that removal of it or the requisite portion is impossible, a photograph of the impression after intensification, when possible, should be taken with the help of a local photographer who will be assisted by a proficient or local expert if necessary, and then sent to the special superintendent of police for examination by the bureau expert. If required, the services of the expert from fingerprint bureau may be requisite, case being taken in the meantime to protect the impression. The owner should be warned not to touch or move the article in question. Study of impression with a view to help searching. Then these are the, your lordship, the procedure, your lordship. Then your lordship may kindly come to D. How it is to be, your lordship, packed and forwarded. Then your lordship, method of dispatch. These are there, your lordship. Now, your lordship, Honorable Apex Court, your lordship, on this point, your lordship, two judgments I am relying on, your lordship. কর্ণাটক এইটো নহয় ফিংগাৰপ্ৰিণ্ট কেইটা ক'ত গ'ল সেইটো 2021 4 আছে only one judgment to para
2021,
4 SCC 345
name,
4 SCC 345
page, the name,
Hariom alias Hero versus State of Uttar Pradesh. কি কৰিছ ভালে one paragraph, your lordship, two paragraph.
para,
Para 32, your lordship, 32 to 34. It's a Karnataka case, your lordship. So Uttar Pradesh, he relied on another case from Karnataka. Para 32, your lordship. According to the record, Exhibit 4 was the punch number testifying the lifting of the fingerprints from the house of the deceased by Constable Dharmendra Singh. If the fingerprints were picked from the glasses, there is nothing to indicate what method was applied to lift the fingerprints from the glasses, allegedly used by the accused when they were offered water. What the record indicates is that some photographs were sent to the office of the director, Fingerprints Bureau, Lucknow, and nothing more.
which paragraph are you reading?
Para 32, your lord.
32.
32.
Yes.
According to the record, Exhibit 4 was the Panchnama, 4-7 was the Panchnama testifying the lifting of the fingerprints from the house of the deceased by Constable Dharmendra Singh. If the fingerprints were picked from the glasses, there is nothing to indicate what method was applied to lift the fingerprints from the glasses allegedly used by the accused when they were offered water. What the record indicates is that some photographs were sent to the office of the director, the same here, Fingerprints Bureau Lucknow, and nothing more. It does not show the procedure adapted for taking such photographs and whether such method is trusted and tested one. The person concerned was not examined who could have thrown light on this
In
issue.
the instant case, it was not photograph, it was the glass pieces.
Ultimately, your lordship, they have taken photographs, your lordship will get in exhibits, your lordship. That is there, your photographs were sent, your lordship. It was photographs were your lordship. Photographs were your lordship.
What was sent for the
Your lordship.
examination? Photographs or the
Lordship will kindly see what they have. Evidence. Exhibit. But even if it is not your lordship, if it is the then also your lordship will kindly note, your lordship, the IO has not
method.
disclosed the method that has not been disclosed. I am on that only, your lordship, the method.
Here in this case, they have not disclosed what method they had
What method
adopted.
they have adopted. That is the on, and your lordship may kindly come to next paragraph, your lordship. 32, 33. 33, there is a reference to your lordship,
Karnataka case.
Karnataka case, and your lordship, there is a Karnataka police manual, your lordship.
Yes,
where-
we have read that.
Then you know 34. The procedure detailed in Karnataka Police Manual captures the importance of development and preservation as well as the method of packing and safekeeping. Such a procedure, if adopted, will not raise any doubt. Secondly, in the aforesaid decision, the conduct of the investigation, keeping the material concerned with him for almost 2 months. That was 2 months here, your lordship. Not
7
2
days.
months, 10 days, your lordship. Was not approved by this court. Now, therefore, your lordship, unless your lordship that is done, your lordship, that cannot be, your lordship, it cannot be said that these fingerprints are not contaminated. Your lordship. There may be, your lordship, possibility, and that possibility, it is for the prosecution to dispel any doubt about the fingerprint, which is a vital piece of evidence in convicting the accused Sanjay Rajwar. Manner they have not mentioned, your lordship. Certain important questions that could have been put to the police in IO, your lordship, that was not put. Therefore, your lordship, I cannot take this other points, your lordship. Then, your lordship, in DNA also, your lordship will find, your lordship, para 113.
Of the judgment.
Of the judgment, your lordship.
Hmm.
DNA tool yes, and exhibit stuff. Thus, the evidence of Digonta Das has fortified the prosecution version that it was accused Sanjay Rajwar, son of Rajwar, who, with the help of material exhibit 1, broken glass piece caused stab injury of size 4 cm and once a muscularly over the medial aspect of right thigh situated so and so. So and so. This is, your lordship, the final finding on this based on fingerprints, your lordship. Then, your lordship, and what I wanted to show, your lordship, from the DNA, your lordship, they have sent it for, your lordship, DNA testing, the blood sample, along with those in the a particular glass, piece of glass. That, your lordship, will find that that has not been matched, not matched, but there are reasons, your lordship. They are not saying that not they could not match it.
No, no, how is it relevant?
That is relevant in the sense, your lordship, the blood sample in that particular piece of glass, which was allegedly used for, your lordship,
Causing the
stabbing,
assault.
causing the stabbing of the disease, your lordship, and the blood of the disease, your lordship, was sent for DNA matching, your lordship. But your lordship, that
Whether the blood stains in the, on the glass pane belong to the deceased,
lordship,
for that purpose.
that your lordship has not been, could not be matched, your lordship. That they have mentioned the reason why that could not be matched. Trouser it matched, trouser may be matched because it is his, but the glass would have shown that whether it is me, I am the one. Then your lordship, 120 is the regarding TIP. TIP has been discarded here. Your lordship may kindly then come to para 128. Lordship will kindly come to para 150, page 658. Thus, we find from the evidences to discussed in the aforementioned paragraph,
Paragraph?
paragraph 128. Thus, we find from the evidences so discussed in the aforementioned paragraph that they have given consistent account of the incident. There is ample corroboration in their version and the same lends unstinting support to the prosecution version as set out in the FIR Exhibit 2. The defense side failed to elicit anything tangible to cast shadow of doubt about the veracity of the prosecution case. It is true that some contradictions are here and there in the versions of some of the witnesses, and the defense side has brought the same on record, but it has failed to prove most of them in accordance with law. It would be apposite to mention here that what would be amounts to omission and what would amount to contradiction, how and contradiction has to be proved, and the true import of section 160, 160 CRPC and section 145, 153, 157 of the evidence has been settled by the Honorable Supreme Court long back in the year 1959 in the case of Tahsildar Singh versus so and so. The position of law, your lordship, in this regard is against reiterated by Honorable Supreme Court in so and so, where it has been held that there is, your lordship. Then your lordship may kindly come to page 660. The judgment is quoted. The attention of witnesses
Yes.
is drawn to that part, and this must reflect in his cross-examination by reproducing it. If the witness admits the part intended to contradict him, it stands proved. It stands proved. Your lordship, it is his own reference to this judgment, and even then, learned court below is saying that, your lordship, I should
No,
have
Madam has,
added that. But your lordship, I am trying to show the
these are
judgment.
positions of law. VK
Lord.
Mishra is very clear.
Lordship. Now, in paragraph 129, in the case in hand, learned defense counsel in his written argument has pointed out some of the contradiction in his versions of the prosecution witnesses with his earlier statement under section 161 as well as this under 164 CRPC, but same could not be proved by the defense side in accordance with law as discussed above. This being the position, same cannot be placed into service to discredit the otherwise clear and cogent evidence so adduced by the witnesses prosecution side. Then 130, your lordship. It is also worthwhile to mention here that the occurrence of the case started at around 4 p.m. and continued till 5:30 p.m. and different prosecution witnesses have arrived at the place of occurrence at different point of time and saw different parts of the incident. Therefore, whatever a particular witness is occasioned to see and observe at a particular point of time, the other missed the same. And as such, some inconsistencies are obviously in their versions regarding the role played by some of the accused persons. though they have given consistent account of the incident, but having assessed the same in the light of established canons of appreciation of evidence, we find that the contradictions so pointed out by the defense side fail to go to the root of the matter as so as to demolish the prosecution story. Having regard to that, all the facts and circumstances, we are inclined to ignore the inconsistencies of the version of prosecution witnesses in respect of the role played by accused person. In doing so, we also derive authority from the case law discussed here in below your. Here you will see the first case that has been referred to, that was in respect of evidence of an injured witness, your lord. Then in para 133, another judgment is referred to. By and large, a witness cannot express to possess a photographic memory and to recall the details of an incident. It is not as if a videotape is replayed on the mental screen. In fact, your lordship, if you go to the statements of the witnesses, more particularly 30 protected witnesses, they seems to have a photographic memory, your lordship. Who give what kick, your lordship, everything they have narrated, even after long elapse of time, your lordship. That, your lordship, actually such distinct statement, your lordship, even after long elapse of time, your lordship, creates doubts about the veracity. Now, your lordship will kindly come to injury part.
You're
Then-
doubting their memory. They may be of good memory.
No, memory, your lordship. Maybe, your lordship. Maybe. No, that's what I am showing this. If this is the manner in which they have narrated everything on, and in fact, your lordship, only these we protected witnesses, your lordship. None other. Only these protected witnesses has seen everybody causing, your lordship, the assault, your lordship. Even Sanjay also, your
So
lordship.
what case will be deemed to be proved? It is too, if it is too perfect, you said too perfect, made out.
It is too.
If it is inconsistent, it is inconsistent. So which-
sometimes when it is
When it
too,
will be a criminal case, how will it be proved?
lordship, when it is too perfect, your lordship, that creates doubt.
They have seen together, they have given the same version
Lord.
after tutoring. That is what you want to
That's
say.
what my argument will be, your lord. Now, your lordship may kindly come to page 667. There they have, your lordship, mentioned
667.
667.
667. Yes.
Then para 139. But the evidence of in para 138, Deven Dutta also sustained injury number D compromising so and so, so and so. Then it cannot be said with absolute certainty as to which one of the accused actually caused the 4 confusions as mentioned in injury number B. That is finding, your lordship, who has caused, your lordship, actually. Then, but the evidence of PW 9, 10, 28, 36, 37, 38, and 44 reveals that accused Sanjoy Rajwar, Bablu Rajwar also assaulted Dr. Deven Dutta, and his presence at the place of occurrence and his taking part in the occurrence is evident from evidence of PW 3, 12, 17, and 32. And the photographs printout which were taken out of the video clippings. Material exhibit 59, these are video clippings, also confirmed his presence in the place of occurrence. Material exhibit 53 also reveals his complicity with the offense. The defense side during argument has contended that evidence of PW 36, 37, 38 against the accused could not be rebutted in cross-examination. That is, your lordship, probably, your lordship, not correct, your lordship. The evidence of PW 32, 36, 37, 38, 39, and 40 clearly established assaulting of Dr. Deven Dutta by accused Sanjeev Rajwar. PW 3, 12, 28, 41, and 44 have confirmed his presence in the place of occurrence, your lordship. Now, your lordship will kindly note, your lordship, out of these, your lordship, 32, 36, all these are, your lordship, the protected witnesses. Established as Deven Dutta by accused Sanjeev Rajwar. And PW 3, 12, 28, 41, and 44 have confirmed his presence in the place of occurrence. In fact, your lordship, out of this, he has not made any statement regarding Sanjeev Rajwar. In your lordship, what I have done, your lordship, I have prepared a chart here. If your lordship go to the chart, your lordship may not, I need not read this. Who said what about this? All other accused person.
Give a copy to the other side.
Lordship, I will get. সেইটো দি এই চিম্বলখন ওপৰত দিয়া। আৰু তাত আধাৰ কাৰ্ড These are your lordship, except protected witnesses, your lordship. What other witnesses are said? If your lordship go through, your lordship will find
Why two copies?
one your lordship in respect of Sanjay Rajwar,
Okay,
the
okay,
rest other papers.
okay.
Who named whom, your lordship? Whether it was stated in 161 or not, your lordship, that also there in the third column. Fourth column. Your lordship, in respect of 2 or 3 accused, your lordship, I just want to show that, your lordship. Your lordship may kindly come to para 141. Only this paragraph I will show you in respect of these 3 accused. We also find from evidence of PW 38 and 44 that the accused Bablu Rajwar assaulted the doctor, and his complicity with the offense and his presence at the place of occurrence was confirmed by PW so and so, and exhibit 2 also lends assurance to the same. And the photographs printout of which were taken from video clippings, material exhibit 88, 89, 90, 111 also confirm his presence at the place of occurrence. Material exhibit 53 also reveals his complicity with the offense. It is worthwhile to mention here that learned defense counsel, while arguing about the veracity of the prosecution, witnesses considered that the evidence of PW 36, 39, 40, 41 against the accused could not be rebutted in cross-examination. From the evidence of PW 10, then your lordship, pausing here for a moment, your lordship will kindly see learned court below has relied on PW 38 and PW 44 that he has assaulted the deceased, your lordship. Now PW 38 is your lordship protected witness, and PW 44, your lordship, he is, your lordship. In fact, the witness, your lordship, we have shown, Duleswar Majhi, he is the person who identified everyone from the, your lordship, video footage, your lordship. And he has admitted in his cross that he has named these persons for the first time, your lordship. All these persons, including Bablu Rajwar. Now, your lordship, the learned court below has, your lordship, applied a principle, your lordship, that's 2 theory, your lordship, that is 2 witness theory, your lordship. Some of the accused were 6 accused were granted acquittal on the ground that your lordship, there are no there are only one witness to show their presence at the place of occurrence. Now here, place of occurrence and the assault, your lordship. Now, your lordship, since only one witness was there, by applying that principle, your lordship, learned court below has acquitted. If going by that principle, your lordship, then only one witness, 38, has in fact disclosed about Bablu Rajwar, your lordship. There is no one other disclosed about the assault by Bablu Rajwar, your lordship. No one else, your lordship. 44 cannot be relied on because he has stated this for the first time, your lordship. By applying the same yardstick, he should have been acquitted also, your lordship. Similar will be the case in respect of your lordship, Anil Majhi, your lordship.
But is it, one or two will not be enough for a,
Maybe, your lordship, but what I am trying to show, your lordship, that the learned court has applied that yardstick, your lordship. One witness, if he is cogent,
Trustworthy.
reliable, your lordship,
trustworthy one witness, why not?
then one witness will be enough. But what I am trying to show is that that's the principle applied by the learned court.
This submission is for Bablu.
Bablu.
A8.
Thank you.
Come back at 2 o'clock.
Lordship.
I may be allowed to go at.
We'll have it till 3 o'clock.
Otherwise, my learned friends are here.
No, we'd like to have you after him.
Okay.
Then we'll,
No, he cannot finish by 3 at. Why?
So judgments are to be shown in your lordship only on that point, death penalty part,
that you have to touch.
lordship. That's right.
This is, you're arguing on the sentence, on the aspect of
Yes.
holding you guilty.
Lord.
Now, if the,
Then your
then
lordship.
the second,
There, your lordship, I will only show two judgments, your lordship, that.
yes.
Lordship. Then your lordship will kindly see Anil Majhi, A9, para 141 itself. Your lordship. His TW10 has TW10 has named him. From the evidence of TW10, we find that accused Anil Majhi also assaulted Dr. Deven Dr. and PW29, 28, 32, 39 confirm his complicity and presence at the place of occurrence. Exhibit 2 also lend assurance to the same. The learned counsel for the accused during argument considered that evidence of against the accused could not be regarded as cross-examination. In fact, your lordship, PW10, your lordship, admittedly has named him for the first time in 164 step, before the court, your lordship, not in place. That has been admitted, your lordship, in cross. And PW20 had not said anything about the Anil Majhi. PW 32 did not state about assault of the doctor by the Anil Majhi, Your Lordship. He only says that he was present. Then Arun Majhi, Your Lordship, he was accused number 11, he was acquitted. Then Your Lordship will kindly see on, and we are therefore concerned to also we find from evidence of PW 11, 28, 32, 36, 38, 39, 41, accused Bijoy Rajwar, A12, assaulted the doctor. Now, though PW 44 said Duleswar Majhi, otherwise learned court below has put heavy reliance on this person, Your Lordship, testified that accused Bijoy Rajwar has tried to save the doctor, yet the evidence of PW 11, 28, 32, 36, 38, 39, 41 are clear and potent enough to outweigh the version of PW 44. Your Lordship will find that the learned court below selectively taking Your Lordship the evidence of PW 44, which favors the accused, he is not accepting it, and which favors the prosecution, that only he is accepting, Your Lordship. That is, Your Lordship, is against the principle of law, Your Lordship. Then para 142, Your Lordship. So far as this Bolin Rajwar is concerned, Your Lordship, accused number 13, the evidence of PW 44 reveals that the accused Bolin Rajwar assaulted the doctor, and PW 17 and 12 confirmed his complicity and presence in the place of occurrence. Further, we find from the evidence of PW 38 and 44 that accused Deepak Raju. Then Your Lordship will kindly PW 44, Your Lordship. I have very the genuinity and Your Lordship reliability of this PW 44 is under serious question, Your Lordship. Based on his statement, Your Lordship, convicting someone, that is accused 13, Your Lordship. And PW 17 for the first time, Your Lordship, named him, Your Lordship, PW 17. And in fact, Your Lordship, he did not speak about any assault by Bolin Rajwar, Your Lordship. And 12, in fact, I did not find mentioning the name of Bolin Rajwar.
Bolin has been
Named only by
convicted by whom? Convicted on the basis of what?
this PW 44 statement, which he has he admittedly he has made for the first time before the court.
44 is
Duleswar Majhi.
Duleswar.
Duleswar.
And 38 you say
No, PW 44, 142. Not Bolin, Your Lordship, Bolin, Your Lordship. PW 44 reveals that the accused Bolin Rajwar assaulted by the doctor, and PW 17 and 12 confirm his complicity and presence in the place of occurrence. Further, we find that evidence of PW 38, 44 that accused Deepak Rajwar, he is the 38.
what about PW 17 and 12?
17, Your Lordship, he has, Your Lordship, did not speak about any assault by the 7.
Only confirmation is
Lost his presence and
his
Your Lordship
presence.
presence. And 12, Your Lordship, I did not find, Your Lordship, naming him, Your Lordship. Bolin was not named by Then your lordship may kindly come to Rinku Majhi, your lordship.
Case 19.
Lordship. The evidence of PW 11 and 44 reveals that accused Rinku Majhi also assaulted the doctor. PW 3, 8, 12, 28, 33, 37, 38, 39, 40, and 41 confirmed his complicity and his presence at the place of occurrence. Now, your lordship will kindly see PW 11 has named him for the first time before the court. Your and PW 44, your lordship, evidence, your lordship. He has also stated, your lordship, he has not named anyone before the police, your lordship. PW 44. 11 and 44.
But 11 for the first time in the court.
Lord.
And 44?
44 also did not state anything about the name of the accused person before the
So he was also first time in the
first
court.
time.
In his police statement, is Duleswar, whom did he name?
No, he has not named anyone, your lord. Your lordship may kindly see PW 44. This is evidence.
Cross actually, fine, nothing in cross. But you might have still not naming it.
I
But
will.
there
I
is
will show.
nothing has come out in the cross that I have not stated or before. start.
I will show.
কিন্তু থাকতেও পারে।
This being matters of records, we can also verify. Do the
Lordship
verification.
can,
that's
your
all.
lord.
But we had need to have a affirmative statement either from you or from him that it's either there or not there.
Lordship, lord. That's your lordship. I have that 44 has your lordship not specifically put that way. That he has named 45. Is correct. So many witnesses, your lordship.
No, we are not on that. She's correct.
Yeah.
But as a matter of record, in 161, did he actually name somebody or no?
That your lordship.
Your inability or your failure to ask a question will not change the records. We will still go by the records.
Lordship, lord. That your lordship will be difficult for me to say.
Now, generally, when it's not put in the cross-examination, presumption will be against you.
Lordship, that's
Because if you have 161 in your hand,
Lord.
then you confront the
Lordship,
witnesses.
Lord.
And
That-
matters of this nature, that is the only statement,
Yes,
the
yes.
only
That
weapon
is not
which you have, armor in your hand, that
Lord.
you will use it
Lord.
to confront the PWs.
Even then, your lordship, so far as PW 44 statement is concerned, your lordship, we have heavily, your lordship, the genuineness of the reliability of the, we have put to question, your lordship. On the ground that, your lordship, he has already been shown the video, your lordship. And thereafter, your lordship, he was asked, and that video, so far as video is concerned, where from it comes, how it comes, That has not been, your lordship, explained there. Then, your lordship, so far as Mixilas Mazi is concerned, your lordship, accused number 20. Same argument I have, your lordship. PW 38 and 44 is Hmm? 38 and 44. PW 28 has said, your lordship, that he was present. 32 and 44 also. 32. কোনে কৈছে? PW 28 has very
Mr.
specific.
Bhattakur, so far as your argument for certification
Lord,
of electronic evidence is
Right.
concerned, that is with regard to the evidentiary value of those videos.
video, sir.
Now, here your submission perhaps, which we have understood, so far as Duleshwar is concerned, he says that he deposed, in his deposition, he says that he was exposed to a video,
Video, yeah.
and that video was prior to the certification.
Lord,
So, but that is nothing to do with the evidentiary value of the video which is before the court
lordship,
subsequently.
Lord,
But you may still argue that what was shown to him was an unauthenticated video,
lordship,
kind of.
that's good.
So therefore, the veracity will be
Lordship.
doubtful.
that is not-
Otherwise, that is not the evidentiary value of this side or that side will perhaps
Lord.
not come.
Lord. Now, your lordship will kindly see, your lordship. Now, which video they have shown it to him, your
Yes, on
That-
that point, and that
Yes.
point you can argue, but
Lordship.
that whether at that stage it could have been an admissible
lordship,
piece of evidence.
lordship,
Because that is not the evidence.
Lord.
He deposes that I was exposed to a video. Video was on a stage when the certification itself was not there.
lordship,
You are otherwise also doubting the certification
lordship.
because it
Sir.
came through a computer. And then the
Computer-
computer, the possessor or the under whose custody the computer was there, he
But
has not given a
That is not
certificate.
given, your. That's
Reporter video are different.
your
This is
lordship.
police video and reporter video is
But
six.
which police has made the
Pol-
video?
Police has not. That's not video, your lordship. There are still photographs by the police. He has taken, the IO has taken some photographs, your lordship.
Please check if the police has made any video. And if so, which police officer has said?
IO has taken certain photographs after, because your lordship.
No, those photographs, if we remember correctly, are on the videos from the
After the
video days.
incident.
Yeah, after the
After the incident, what is there, your lordship? The damaged table, chairs, room, these are there, your lordship. Blood. Now, your lordship, page para 143, your lordship.
yes.
Para 143, we also find from evidence of PW 103244 accused. Your lordship, rather than your lordship reading and pointing out, it will be better for in my written submission, your lordship,
Yes.
these I will put, your
Yes,
lordship.
yes,
That will, your lordship,
yes, yes.
help, your lordship. Now, your lordship. Para 150, your lordship,
150.
150.
Yes.
Now, what remains to be seen is whether it will come under any of the exceptions under 300 IPC. It may be mentioned here that there are 5 exceptions to section 300 IPC. under which if murder is committed, it is reduced to culpable homicide not amounting to murder, punishable under section 304 Act.
This we may not agree upon.
Lordship, Lord,
It is not only the exception.
Lord,
It is not only this exception, it's a principle of law.
Lord,
299 is different, 300 is different. There are 5 exceptions. It's a different matter,
Lordship,
which will make culpable homicide not a motive murder. But it's not the case that if this doesn't fall under those exceptions, it will be murder automatically.
Lord,
It can still be a culpable homicide 299.
Lord,
What is the extent of the knowledge?
Lord,
What is the extent of the likelihood to cause the death?
Lord.
What is the extent of the intention? Those are settled.
Lord.
I
Now,
don't think
your Lordship, but I have just wanted to point out how the learned court
No,
below
this
dealt with.
perhaps
Lord, Lord, just one. Human case number.
no, we do not know. There may be other discussion whether
211.
299 or 300, but it cannot be said that only because it doesn't fall under the exception,
Lord.
so automatically 300 will
Lord.
come. Not like that.
Then your Lordship will kindly come to para 152 and 153, 153, 155, your Lordship.
One?
155, page 678. Itu tuh, itu Kumar Soiker tuh, Garnet. Garbage. The manner in which all the accused person assaulted Dr. Deven Dr. did not allow him to take the hospital even after serious injury and chased away the 108 ambulance. The slogans they have chanted clearly shows that they had a predetermined mind to kill Deven Dr. at any cost, and they have translated the same into action and achieved it. Ultimately, this is a clear from the conduct of accused Manoj Bhati, who took Deven Dr. to his chamber and made him to sit in chamber while he was coming out of the hospital after death of Samara Bhati. After some time, he is coming out of the chamber of Dr. Deven Dr. 34.
Just a minute.
Lord. Why and the slogans have chanted clearly shows that they had a predetermined mind to kill Dr. Deven Dr. in any cost, and they have translated the same into action and achieved it ultimately. This is clear from the conduct of the accused Manoj Bhati, who took Deven Dr. to his chamber and made him to sit in his chamber while he was coming out of the hospital after the death of Samara Majhi. This statement, your Lordship, has been said by the PW, your Lordship, Somen Kundu, your Lordship. But your Lordship, he has admitted that this is for the first time he has stated before the Honorable Court, your Lordship.
Which part?
This part, your Lordship. This is clear from the conduct of accused Manoj Bhati, who took Dr. Deven Dr. to his chamber and made him sit in this chamber while he was coming out of the hospital after the death of Samara Bhati. After some time, he is coming out of the chamber. Dr. Deven Dr. 30-40 persons gathered outside the Garden Hospital. He was found addressing 8-10 persons outside the chamber of Dr. The doctors should have been removed long back by management, and they have given application to the management, which fact is admitted by him in his statement under section 313 CRPC also. They caused the injury number A, B, C, D, E to Dr. Deven Dr. of this injury only. Injury number D comprises of 4 contusions and the same were on the head of the disease, which is a vital part of the body. Injury number E, which was on the upper part of the chest, involves fracture, and third, and fourth ribs which protect vital organs such as heart and lungs, etc. Powerful blows on these parts of the body can in normal course result in death of a person. Injury number 8, though not vital part of the body, yet it involves partially cut and separation of the right femoral artery, and according to medical evidence, the injury alone is sufficient to cause death of a person in the ordinary course of nature, which has happened here in this case. It might have been possible to once say that they had come there not with the object of committing murder, but only with the object of beating and abusing the doctor. But in a view of the manner in which they chanted slogan and manner in which they have acted thereafter clearly establishes that the object was not inflict injuries simpliciter. The disease sustained serious injury on his person, and even on the mob did not allow the law and order magistrate and police personnel to take him to the hospital and rebuff the appeal made by magistrate and also the appeal of the management of the garden. They chased away 108 ambulance by treating the technician and the driver of the same. They inflicted as many as 5 injuries, and out of the same injury number D, which comprises 4 contusions were on the head, which is a vital part of body. That apart, injury number E, which was on the upper part of chest, involves fracture of third and fourth ribs, which protects vital organs such as heart and lungs, etc. Powerful blows on these parts of the body can in normal course result in death of a person, as happened in the case before us. The way in which crime has committed reflects nothing but sheer brutality. The members of the assembly therefore were aware that their acts were going to result in the death of the disease. Therefore, there is no merit in such contention. In arriving at such conclusion, we derive authority from following decision of the Honorable Supreme Court in Atmaram versus so and your lordship will find, your lordship, in this particular case, there were injuries, 19 injuries were there, your lordship.
Atmaram.
In Atmaram. In page 69, 681, your lordship will find, just as in Anda case, here also the aim of the assailant was to smash the arms and legs of the disease, and they succeeded in that design, causing no less than 19 injuries, including fractures of most of the bones of the leg and arms, while in Anda case, sticks were used by the assailants were not specially dangerous. Now, your lordship, this case, your lordship, is completely in a different footing, your lordship. The injury itself shows, your lordship.
No, in Atmaram, hard coated is more on the Andhra Pradesh case.
Lordship.
This is
Yes,
not
sir.
Atmaram.
Atmaram has referred to Andhra Pradesh
So
case.
it's better to directly refer to Andhra Pradesh because
Lordship.
these are quotation paragraph 38 from the Andhra Pradesh case, 19
Lordship.
number of injuries.
Lordship.
Then, and in the case of Anda,
Under your lordship, they have used lathis, your lordship.
okay, Rajasthan case.
Lordship. Anda versus state of Rajasthan.
Whatever.
Then your lordship, 162. What is to be proved by the prosecution, your lord?
Coming to 162.
162, your lordship. That learned court below has referred to Supreme Court judgment, your lordship. In
Yes.
what-
Virsa Singh.
Virsa Singh, what is to be proved, your lordship, by the prosecution? Once these 4 elements are established by the prosecution, and of course the burden is on the prosecution throughout, the offense is murder under section 330. It does not matter that there was no intention to cause death. It does not matter that there was no intention even to cause an injury of the kind that is sufficient to cause death in the ordinary course of nature. Not that there is any real distinction between the two. It does not even matter that there is no knowledge that an act of the kind will be likely to cause death. Once the intention to cause the bodily injury actually found to be present is proved, the rest of the inquiry is purely objective. That only question is whether, as a matter of purely objective inference, the injury is sufficient in the ordinary course of nature to cause death. No one has a license to run around inflicting injuries that are sufficient to cause death. The ordinary course of the nature and claim that they are not guilty of murder. If they inflict injuries of that kind, they must face the consequences. They can only escape if it can be shown the reason the injury was accidental and otherwise unintentional. In Gokul Purusharam versus so and so, then your lordship, then 165 your lordship. It is about Sanjay Rajwari. Now, reverting to the facts of the case in hand, we find that injury number A sustained by the deceased Dr. Deven Dotto alone is sufficient to cause death of a person in ordinary course of nature, and since it was fatal blow caused by the accused Sanjay Rajwar, as son of Babu Rajwar, his liability would be to direct here in this case. It is to be mentioned here that conviction under section 302 IPC implicit or without the aid of section 149 IPC is permissible if overt act is attributed to the accused, resulting in the fatal injury which is independently sufficient in the ordinary course of nature to cause the death of the disease and is supported by medical evidence. Reference in this context may be made to a decision by Honorable Supreme Court in so and so versus so and so. Since the other injuries are also caused by the accused are not fatal injuries, but together with injury number A have cumulative effects which lead to hemorrhage and shock and ultimately death of Deven Dotto, the liability of accused so and so, so and so, so and so, so and so, all these accused would be constructive, which is being dealt with here hereafter. Now we will deal with the offense under section 149, your lordship. Now, your lordship, by 149, your lordship, the other accused persons were convicted by the learned court below, your lordship. Then there is, your lordship, para 179, your lordship. The learned court below determined the common object of the assembly. এটাই করছি। Specific role, your lordship, attributed to different
180,
86, your lordship, page 701. And these were, your lordship, in respect of 6 accused who were acquitted, your lord. And there is a reference to two witness theory in para 197. Based on this two witness theory, there's 6 accused who were acquitted. Then your lordship will kindly come to para 202.
This two witness theory is mainly applicable in 149
Lord,
while roping in
lordship,
149.
your lord. Now your lordship may kindly come to 202, your.
Hmm.
After they were, your lordship, acquitted, your lordship. Of course, it may be argued that since accused Anil Majhi, Deveswar Rajuar, and Sanjoy Rajuar alias Toklu were seen assaulting doctor by a single witness, the test of consistency so laid down by the Honorable Court in Masati versus so and so is applicable in their case also. But in a later judgment, if it is, your lordship, applicable, then but in a later judgment in state of Maharashtra versus Ramlal Developer Rathore and others, appeal number is disposed of on so and so. Honorable Supreme Court explained the ratio on Masalti as under. We do not find anything in Masalti which in any way qualifies the well settled principle that conviction can be founded upon the testimony of even a single witness, if it establishes a clear and precise of the overtake constituting the offense as committed by certain named assailants, if such testimony is otherwise reliable. The test adopted in Masalti is required to be applied while dealing with cases of those accused who are thought to be made vicariously responsible for the acts committed by others only by virtue of their alleged presence of the members of the unlawful assembly without any specific allegation of overt acts committed by them, or where, given the nature of assault by the mob, the court comes to the conclusion that it would have been impossible for any particular witness to have witnessed the relevant facets constituting the offense. The test adopted in Masalti as a rule of prudence cannot mean that in every case of mob violence there must be more than one eyewitness. It is a fact that the accused Anil Majhi was seen assaulting doctor by PW10 only. PW3 found him present in the mob, and PW32 found him standing inside doctor's chamber. There is no evidence to support the version of PW10 about assaulting the doctor by the accused. Other prosecution also did not see him assaulting the doctor. Similarly, accused Deveswar Rajuar, Debo alias Jogeshwar Rajuar, was seen assaulting the doctor by PW28. PW32 found him along with Hari Majhi, Deepak, so and so, demanding that doctor should be traced and assaulted. No other witness seen him assaulting doctor, and to lend assurance to version of 28. On the other hand, Sanjoy Rajuar's Taklu was seen assaulting by the doctor PW44 only. It is to be mentioned that here this witness named accused Sanjoy Rajuar as Taklu amongst the 20 accused that he named in examination sheet, but no other witness corroborated the version of PW4. But the evidence of specific overt act attributed by the prosecution upon these 3 accused remain uncontroverted. That, your lordship, could not be understood, your lord. Besides, there are also other facts and circumstances on the record to lend assurance to the same, therefore, and also relied upon the decision of Supreme State of Maharashtra so and so. We are inclined to hold that test of consistency is not applicable in case of 3 accused named above. This paragraph itself, your lordship, is very contradictory in nature, your lord. There is specific finding that no one corroborated his statements, Your Lordship. The accused in the statement of PW3, PW10, Your Lordship. A clear admission. In spite of that, Your Lordship, by referring to why this principle laid down in subsequent judgment of Maharashtra case is applicable for this, that has not been explained here, Your Lordship. Without explaining this, Your Lordship, only by referring to it, Your Lordship, this conviction is, Your Lordship, given, Your Lord, to these three accused persons, Your Lord. They are in fact going by the logic of two witness
Witness.
theory, Your Lordship. They are also entitled to be acquitted, Your Lordship. Then, Your Lordship, rest, Your Lordship, I am not reading, Your Lordship. These are the main charges, Your Lordship. Then last part, Your Lordship, on punishment, Your Lordship, that I will come later on. Now, Your Lordship will kindly come to section 65B, Your Lord. Your Lordship, got it.
Yes.
Admissibility of electronic record. Notwithstanding anything contained in this act, any information contained in an electronic record which is printed on a paper, stored, recorded, or copied in optical or magnetic media produced by a computer, hereinafter referred to as computer output, shall be deemed to be also a document if the conditions mentioned in this section are satisfied in relation to the information and computer in question, and shall admissible in any proceeding without further proof or production of the original as evidence of any content of the original or of any fact stated therein of which direct evidence would be admissible. The conditions referred to in subsection 1 in respect of computer output shall be the following, namely the computer output containing the information was produced by the computer during the period over which the computer is used regularly to store or process information for the purpose of any activities regularly carried on over that period by the person having lawful control over the use of the computer. During the said period, information of the kind contained in the electronic record or any kind from which the information so contained is derived was regularly fed into the computer in the ordinary course of the said activities. Throughout the material part of the said period, the computer was operating properly, or if not, then in respect of any period in which it was not operating properly or was out of operation during that part of the period was not such to the effect that electronic record or accuracy of its contents, and the information contained in the electronic record reproduces or is derived from such information fed into the computer in the ordinary course of the said activity. Where over any period the functions of storing and processing information for the purpose of any activity is regularly carried on over that period, as mentioned in clause A and subsection 2A of subsection 2 was regularly performed by the computer, whether by a combination of computer operating. This is not required, Your Lordship. In any proceeding where it is desired to give a statement in evidence by virtue of this section, a certificate doing any of the following things, that is to say, identifying the electronic record containing the statement and describing the manner in which it was produced. Your Lordship will kindly note that, Your Lordship. Manner in which was produced. Giving such particulars of any device involved, giving such particulars of any device, Your Lordship. Any word is very important here, Your Lordship. Any device involved in the production of that electronic record as may be appropriate for the purpose of showing that the electronic record was produced by a computer, dealing with any of the matter to which the conditions mentioned in subsection 2 relate. Now, Your Lordship will kindly see when it says any device, there are two devices involved, Your Lordship. One is the mobile, Your Lordship, in respect of which there is a 65P certificate, and another device is, Your Lordship, where, Your Lordship, from the mobile it was uploaded in a computer, then, Your Lordship, it was case CD, and then your lordship, it was placed before the honorable court. And now your lordship, in respect of that computer, if there is no 65B certificate, your lordship, then your lordship, this video footage is vitiated, your lord. Now your lordship will kindly see, this is more important for the fact that your lordship, on the one hand, the persons PW 42 and PW 43 in their evidences says that after 3 or 4 days we have handed over this to the police. Then police issues notice on 14th, your lordship. The same was, your lordship, handed over in the police station itself as per the statement of the PW 43, your lordship. And in that view of the matter, your lordship, it becomes more important that to have no doubt about the, your lordship, the genuinity of the video footage, your lordship, this certificate in respect of that particular computer which they have been used, your lordship, will have to be, your lordship, given, your lordship, by way of a 65B certificate. Failure to do so, your lordship, will be fatal to the prosecution case so far as the video footage based on which identification was made, your lordship. This is my humble submission so far as this is concerned. Now, your lordship will kindly see what the Honorable Apex Court has held, your lord. First, it was PV Anwar case, your lordship, where Honorable Apex Court has, your lordship, it starts from para 14, your lordship. I am relying on para 14, your lordship, 15, 16. Your lordship, 16, may I read, your lordship?
Just a minute, please. 14.
14, 10 SCC 473.
Para?
14, 16, 17, 18. Your lordship may kindly read para 16. For up to 21, 23, I am relying, your lordship. And the mobile phones are not seized, your lordship, that your lordship.
You like to read 16?
16. It is further clarified that the person need only to state in the certificate that the same is to the best of his knowledge and belief. Most importantly, the certificate must accompany the electronic record like computer printout, compact disc, video, compact disc, pen drive, etc. pertaining to which the statement is sought to be given in evidence. When the same is produced in evidence, all these safeguards are taken to ensure the source and authenticity, which are the two hallmarks pertaining to electronic records, sought to be used as evidence. Electronic records being more susceptible to tampering, alteration, transposition, excision, etc., without which safeguards the whole trial based on proof of electronic record can lead to travesty of justice. This is the most important part, your lord. That is why, your lordship, this safeguard, procedural safeguard. If they fail, your lordship, then this will go, your lordship. This is my humble submission, your lordship. And then, your lordship, the other judgment, your lordship, the subsequently, your lordship, (2027) SCC 1, your lordship.
You need not photocopy the entire judgment. You can give the relevant pages
Lord,
and the first
already
page.
for
No, I'm just telling you.
Lord,
Because nowadays we have to reduce the number of pages.
lordship, Lord,
We have electronic copies.
Lord.
You can give so, but for our benefit, the first page and the pages where
Lord.
you,
Oblige. Para 32, 33 euro. Coming back to section 65B of the evidences, subsection 1 needs to be analyzed. The subsection begins with a non-obstandent clause and then goes on to mention the information contained in an electronic record produced by a computer, which is by a deeming fiction that made a document. This deeming fiction only takes effect if the further conditions mentioned in the section are satisfied in relation to both the information and the computer admissible in any proceeding. The rewards without further proof or production of the original make it clear that once the deeming fiction is given effect to by the fulfillment of the condition mentioned in the section, the deemed document now becomes admissible in evidence without further proof of production of the original evidence of any content of the original or of any fact stated therein which direct evidence would be admissible. The non-obstandent clause in subsection 1 makes it clear that when it comes to information contained in electronic record, admissibility and proof thereof must follow the drill of section 65B, which is a special provision in this behalf. Section 62 to 65 being irrelevant for the purpose. However, section 65B1 clearly differentiates between original document, which would be original electronic record contained in the computer in which the original information is first stored, and the computer output containing such information, which then may be 65 differentiate between original information contained in the computer itself and copies made therefrom, the former being the primary and later being the secondary evidence, your lord. Then para 34, your lordship. PV Anwar is uphold, your lord. That's. Now, therefore, your lordship, in my humble submission, your lordship, these identification by the PPW 444, your lordship, based on which your lordship learned trial court, your lordship, put heavy reliance, your lordship, cannot stand the scrutiny of the law, your lordship, in view of the violation of the provisions of Evidence Act, your lordship, more particularly 65B. Now, your
But
lordship,
the evidence of electronic evidence, it is proved by whom?
your lordship, it is proved. Now, your lordship,
It
here
is
your
proved
lordship,
by whom?
it is proved by the your lordship PW 43 and 44 in respect of their.
No, 44 said that I was exposed to
Not
this.
44, your lordship, 42 and 43. Two journalists from which these video footages are taken. They are
The one who had given the certificates.
certificates, your lordship. The journalists. Your lordship. There are other photographs also, which is by the police officer, your lordship. From his mobile, he has certified it, your lordship. We cannot, your lordship, dispute that, your lordship. He himself came to the dock and said that these are the photographs in this.
But the films which were made, the videos which were made, were proved as evidence.
Lordship.
What evidence? Material exhibit what?
Material exhibit, your lordship, they took photographs, your lordship. First, your lordship, material exhibit 55 onwards, your lordship.
What
54
about the
onwards.
film? What about the video?
Video is also, your lordship, part of that. Through CD, your lordship, it was brought.
CD has been exhibited by the by whom?
By
The journalist.
journalists as well as the your lordship IO and the Dules are only identified based on that photograph. Now, your lordship, there are 4 number of videos, your lordship, will be there, your lordship. First, your lordship, which PW3, the informant, and the PW28, the writer of the FIR, your lordship, Muktazoti Borua, they both of them talks about a video, your lordship. That on the same day, your lordship, they have gone through that video, and your lordship, they put the names, your lordship, based on that. Second video came up, your lordship, when Duleswar went to the police, your lordship. Now, on the next day itself, Duleswar went, your lordship, PW 44, he was shown certain videos. Now, third set of videos, your lordship, third number of video is one, which after 3 days, your lordship, the 43 and 42 and 43 PW, your lordship, they handed over to the police, according to them. Then the fourth,
After notice.
after notice, your lordship. Now, which is the video, your lordship, will have to be relied. And who knows, your lordship, that this is not, your lordship, interpolated, your lordship, that there are some. So it may be, your lordship, that video is, in fact, there is nothing made to this video, your lordship. But the fact remains, your lordship, this is not about this case only, your lordship. Ultimately, to dispel any doubt about the genuineness of the video, your lordship, they will have to follow the procedure laid down in law, your lordship. And in fact, your lordship, if your lordship sees the exhibit, your lordship, again, your lordship, for a moment,
Journalist numbers are what? PW?
for 42 and 43.
Yes.
Your lordship has already gone through this. Sir. Now, therefore, your lordship, it will go, and your lordship will kindly see, so far as the entire case is concerned, your lordship, as I have pointed out at the very outset, your lordship, there are 4 sets of evidence, witnesses, your lordship. PW, those belonging to the management of the staff, your lordship, and second set is the police persons who are present, and third set is, your lordship, protected witness, and fourth set is, your lordship, journalist, your lordship. Now, out of these 4, your lordship, groups, your lordship, except the protected witness, all other witnesses have, your lordship, improved their statements before the court, your lordship. They have virtually named most of the accused persons for the first time, which I will place, your lordship, by way of my written submission. And then, your lordship, only these protected witnesses have specifically mentioned about the accused persons, and the specific acts were attributed to each of the accused persons, your lordship. Now, your lordship will kindly see these these protected witnesses from the evidence. Your lordship will find that each of the protected witnesses said around 20 to 21% assaulting the doctor, your lordship. This is person, your lordship. Now, 20 to 21% assaulting the doctor, your lordship, only 6, your lordship, injuries have taken place. And your lordship will see, your lordship, that some of the injuries are, your lordship, 5 injuries are, your lordship, contusions, your lordship, except that fracture in the ribs, your lordship, 3rd and 4th rib, your lordship. Contusions, your lordship. Now, your lordship, we can imagine that situation, your lordship, 20% kicking, and your lordship, there is, your lordship, beating a person, your lordship, and ultimately what can happen to this, your lordship. Vividly, they have described, your lordship, that this man has done this man has done this. If we go by that, your lordship, the injury will have to be more, your lordship. This fact, your lordship, this oral evidence is, your lordship, is belied by the medical evidence, your lordship. That's why, your lordship, serious doubts, your lordship, I am raising serious doubt about the genuineness of the evidence of these particular protected witnesses, your lordship. And your lordship will kindly note, your lordship, a video footage is there, your lordship. The PW 43, 2 and 43, more particularly 42, is saying that he has captured the entire incident, your lordship. And why we have not found there that particular, your lordship, the act of the Sanjay Rajwar assaulting this the diseased, your lordship, that is not available in the video record, your lordship. That is not there, your lordship. And in fact, if your lordship sees the video footage as photographs, your lordship, there is few, your lordship, of photographs of assault, your lordship. Only one or two, your lordship. Rest, your lordship, the persons are present there, your lordship. Except that is more than that, it is not there, your lordship. And if Sanjay Rajwar had in fact stabbed it, your lordship, then it would have been seen by the manager, your lordship, PW3. It would have been seen by the PW28. It would have been seen by your lordship, Prakash Rajwar, who was not brought and recorded as an evidence, your lordship. It would have been seen by the police personnel, your lordship. None of them have seen it, your lordship. And one of the, your lordship, the persons who have, your lordship, named Sanjay Rajwar, your lordship, PW37, your lordship, he has categorically stated that when he was there, entered there, the PW4, the manager and the PW3 and the PW28 and some police personnel are there. And thereafter he has seen this, your lordship, which is in fact contradicted by the evidence of PW, some of the witnesses, your lordship. These improvements, these are completely brushed aside by the learned court below, saying that we have not been able to bring that to record through confirmation by the police officer. This is in my humble submission as this has, your lordship, vitiated this judgment, your lordship. And there are contradiction, conjecture, surmises based on that the learned court below has, your lordship, convicted this person, your lord. There is no material at all, your lord, which legal material, your lordship, based on which this conviction could have been given, your lord. I have shown, your lordship, from the evidences, your lord. And your lordship will have seen how, your lordship, contradictory stand has been taken by. And your lordship will kindly see the doctor has specifically said that this may be the cause, that, your lordship, in the learned trial court, your lordship, while using those phrases, your lordship, maybe it has not been used. The word used is, your lordship. This is the cause. This can alone cause, your lordship. That is not there, your lordship. Therefore, in my humble submission, your lordship, these defects have not been considered by the learned court below. This judgment itself is vitiated by such non-consideration of the relevant facts, your lordship. Now, your lordship, one judgment I am relying on, your lordship, on the naming of the accused person in the FIR itself, your lordship, recent judgment, your lordship.
I'll follow it from the video and I'll get. Lordship will allow.
How long will you take, Mr. Bothap?
No, not much time.
You finish it today?
I will finish it.
Okay.
I'll be tomorrow then.
Yes, we'll continue tomorrow. You can,
Okay.
the rest part, you can just have something for colleagues, make some notes or
Okay.
something.
I'll get. First.
মুকুট ডাকবো না আপনার সাথে। হ্যাঁ? Para 28 euros. This is we have your lordship downloaded from the website of this. There are 28, 29 euros.
Hmm.
It is pertinent to note that according to the three eyewitnesses, there were three accused. However, in the affair, only the name of one of the respondent accused were included. The first informant claiming to be an eyewitness has not explained why he omitted the name of the other two co-accused in the affair. If he claims to be an eyewitness to the incident and states to have witnessed three persons known to him assaulting his son, that is the disease, then what was the good reason not to name the other two accused in the affair? This omission assumes significant is a relevant fact under section 11 of the Evidence Act. And they had, your lordship, non-mentioning of the name of the Sanjay Rajwar even after 6 hours of the incident, your lordship, after getting all information from the staff, your lordship, is a relevant fact, your lordship. And few judgments I am relying on, your lordship. I will not read, your lordship, only paragraphs I will cite.
In that case, Supreme Court case, the informant was an eyewitness.
Lordship. Here, your lordship, he was there, your lordship, PW3. And the PW28, who was the person who have, your lordship, written the affair, your lordship, he was also there. It was 2014 PSC, 2015 7 2015 7 SCC 178.
2015, 7
2007
SCC.
SCC 178.
1
78 euros.
name.
Named Thomas Bruno and another versus State of UP, Uttar Pradesh. I am relying on your lordship 19, 27, 32, and 39. This is on your lordship. The exaggerations, your lordship. Improvements in the evidence, your lordship. Your lordship will go through your
Para.
para 19, 27, 32, and 39.
19, 27, 32.
And 39. Your lordship will go through it. Then your lordship 2014 pre-SCC 412. This is also on your lordship contradictions, inconsistencies, exaggerations, your lordship, and material improvement.
2014,
3 SCC 412, para 13 and 14, your lord. And also 16. 13 and 14, your lord. Then one more judgment, your lordship. 2009-11 SCC 106, para 7. 2009-11 SCC 106, para 7. Your lordship, here your lordship, certain things are admitted, your lordship. That is, your lordship, first of all, that incident had taken place, your lordship, number one. Number two, your lordship, that this person has received the injuries, your lordship. Third, your lordship, that our presence there in your lordship, we have not denied that. No, sir. These are the only questions that is to be seen, your lordship. Whether your lordship, what overt act your lordship is attributed to us. And if that act is attributed to us, if any act is attributed to us, whether it is your lordship, whether it is by way of producing evidences which can be termed as legal evidence, your lordship, which will be taken note of by the honorable court here. Only that aspect is there, your lordship. And in my humble submission, your lordship, there is serious doubt about those evidences, your lordship. And your lordship, it cannot be said, your lordship, that the prosecution has been able to prove their case beyond reasonable doubt. Your lordship. It can be a preponderance of probability, and if it is preponderance of probability, then your lordship, we are entitled to a certain kind of relief. It may not be in case of acquittal, your lordship. That's different matter. But your lordship, some kind of relief, your lordship, and at least 30
No, Mr. Borthakur, we may not agree with that.
Lord,
See, the aspect of sentencing
Lord,
and aspect of proof is a different aspect.
Lord, Lord.
Proof can be beyond, it has to be beyond all
Rouse
reasonable
the-
doubt.
rouse the-
That is required. It can be circumstantial, it can be eyewitness. Only because it is circumstantial will give less sentence. That is not the
No, that is
law.
not I
Law
have
is
submitted.
how do you prove it? If it is proved, what is the manner of proof? That is a different matter.
Lordship.
But it has to be proved beyond all reasonable doubt.
Lord.
Now, once it is done, now the court will not come back. Oh, no, there was no eyewitness, so will not give a severe penalty.
No, that is not my submission. What my
So
submission
what
is,
is your, what is the submission?
my submission is that for 302, your lordship, probably the honorable court has, the prosecution has failed to prove beyond reasonable doubt for 302. Why I am submitting this, your lordship? Your lordship has seen the situation, your lordship. It is not premeditated, your lordship. Ultimately, your lordship, it is what has happened? A person has died, and when a person is died, your lordship, when there is a commotion, your lordship, doctor was not present at the relevant point of time, your lordship, and when doctor was not present, your lordship, it is around 3, your lordship. This is a time when doctor should have been there in the hospital itself, your lordship. Nurse is not present there at the relevant point of time. These are, your lordship, apparent from the evidences of the witnesses, your lordship. So, your lordship, people got, your lordship, infuriated, and ultimately, your lordship, something, your lordship, has happened, your lordship. Now, your lordship will kindly see assuming for a moment that, your lordship, this stabbing has, your lordship, done by these accused persons. Now, one of them, your lordship. Now, it is an assault, your lordship, stabbing in the thigh, your lordship, and it is due to, your lordship, cutting of femoral artery. It is which according to them is a fatal. Now, your lordship, normal person cannot have an idea that by doing that act, your lordship, a person can die, your lordship. That, your lordship, will kindly note, your lordship. Even I do not have any idea that the attack on this and this, there is a femoral artery, and if we cut it, that intention was probably not there on their part, your lordship. That it will lead to, your lordship, death, your lordship. That, your lordship, will, that what, your lordship, I want to impress upon this honorable court, your lordship. Unless that intention is there, your lordship, and if, your lordship, unless it is, and that intention is there, it cannot be said that his intention is to kill him, your lordship. Now, your lordship, will kindly see, your lordship, that why I am, your lordship, right now I did not bring that data. Your lordship will find in most of the tea garden hospitals there is a lack of doctors, your lordship. This is an issue, your lordship. It is affecting the tea garden laborers, your lordship. There is a report by the National Health Mission, your lordship, which shows that most of the tea garden hospital, your lordship, lacks, your lordship, the doctors and, your lordship, basic facilities, your lordship. These issues has, your lordship, and the absence of the doctor at the relevant time, your lordship, created no doubt about that these kind of, your lordship, death, your lordship, is heinous and tragic, your lordship, no doubt about that. But to call it a, your lordship, premeditated murder, your lordship, that will be too far-fetched in my humble submission. There is an instantly something has happened, and that, your lordship, that has happened, and probably, your lordship, in the heat of the moment, your lordship, people reacted in that manner, your lordship. And what your lordship, premeditated, your lordship, has been defined in Black's Law Dictionary, your lordship, premeditation. Your lordship will see, it says, premeditation, conscious consideration and planning that precedes some act. There must be some planning, your lordship. There must be some conscious consideration.
Kindly give that page.
Your lordship, I will give
Make a
you.
photocopy of
I
that
will give.
page.
So, your lordship, from the materials available or materials brought on record by the prosecution, your lordship, that premeditation is absent, your lordship. It was in the heat of the moment this has happened. Tragic incident had happened or not have been happened, your lordship, and people reacted to a certain, in this kind of situation, your lordship, because of, your lordship, their the backwardness under which they are living, your lordship. That is a relevant fact to be considered by dishonorable court, even while you are considering the punishment also, your lordship. This in therefore, in my view, your lordship, this is not a case of, your lordship, 302, your lordship. At best, it is a case for, your lordship, 304 part 1. This is my humble submission. And so far as few of the accused persons are concerned, I have shown at least 3 and 4, your lordship. They are, your lordship, entitled to acquittal by the standard applied by the learned court below your itself, your lordship. That has also not been done here, your lordship.
How many persons have been acquitted?
Your lordship, 6 person has been acquitted. As on 2. 1 person has died. 6
During the trial.
during trial. Now, your lordship, on the point of sentence, your lordship, I will not take much time, your lordship. Lordship has already seen Bachchan Singh and Mati Singh, your lordship. Recent judgment, your lordship, that I will rely on, your lordship. And in fact, your lordship, the Bachchan Singh, your lordship will find the last part, your lordship, there is a dissenting judgment by P.N. Bhagavati, your lordship, honorable judge. But that judgment only of 2 paragraphs. But subsequently, after 2 years, your lordship, he has, your lordship, give the reasons, your lordship, elaborate judgment, your lordship. There, your lordship, the Justice P.N. Bhagavati has, your lordship, give a detailed analysis why death sentence is required to be, your lordship, which it is not constitutional, your lordship. I could not find it out, your lordship, from my accuracy.
No, we are not on the debate of whether
Lord,
that.
no, I am
It's a prescription of law.
Lordship.
You can make out a case that it is not a case of
Lordship, I
arrest
will
of
show you.
RR test. So,
2023 2 SCC 35
Manoj,
Manoj, sir. Para 210, your lordship, on sentence. This is also a death sentence, your lordship. It was also a death sentence.
yes, so which paragraph?
Para 210, your lordship. On sentence. May I read, your lordship?
Yes.
The hearing of this case was adjourned for sentencing on a subsequent date, before which the learned counsel submitted material regarding the lives of the accused both before the incident and post conviction by trial court, jail reports and other materials called for by this court were received from the state, written submissions were filed by court. In the course of argument, the learned AG maintained that there were no mitigating circumstances and the cruelty evident from the nature of the crime warrants nothing less than the capital punishment, which according to her was correctly imposed concurrently. It was submitted that it is in cases like the present one where the rarest of rare the crime needs to be invoked as a deterrent. On the other hand, the counsel for the accused laid emphasis on the fact that neither of the courts below had even considered the possibility of reform. In the present case also, Your Lordship, of the accused who were all young age and
We are slightly aware of this Manoj case. When is the impugned judgment of which date?
this judgment, Your
No, no,
Lordship.
our judgment.
Our judgment is, Your Lordship, 2000. Yes, sir.
Because even if his conduct in the jail, everything are relevant consideration.
Lordship.
Manoj has laid.
That
down.
has not been considered.
Manoj came subsequent. That is why we are trying to have the date.
Appeal to Saleh hoto.
But principles of law laid down the court will have retrospective effect. It's not a
Lord-
law by the
Lordship,
parliament or.
Lord.
Here in this is madam. For a death sentence, many principal parameters. of
12/10/2020.
is conduct in the jail. Because looking at the data, how it is only in extreme. Whereas the extreme, so there's a sentence. If he had any remorse in the jail, his conduct in the jail, all other things. Yes. What is it?
Para 214, Your Lordship.
This Manoj is of 2022. 22 Manoj. No, the date of the judgment. But. Starting from under the court itself says that from today onward this law. I'll give an example. In the personal proceedings, there was an issue of inquiry report giving not giving. In one case, one of them if you don't give a copy of the inquiry report, it will be shared with the no? It was a scheme, and you tell them that. It's not a fact, the proceedings which have already been over. So, can you give a perspective in the date of the judgment? Yes.
Lordship, 214 on. First two paragraphs, Your Lordship, the submission. Capital punishment is prescribed in numerous IPC offences, including murder, kidnapping for ransom, rape and injury causing death or leaving a woman in a vegetative state, rape or gang rape of a child below 12 years old, dacoity with murder, among other offences. In Bachchan Singh versus State of Punjab, this court
It
has
is not
upheld.
Bachchan.
Bachchan.
It is Bachchan,
Bachchan.
not Amitabh Bachchan. Bachchan.
Bachchan Singh versus State of Punjab. This court has upheld the imposition of death penalty as an alternate punishment under Section 302 IPC on the strength of the 35 report of the Law Commission of India. The judgment in Jagmohan Singh versus State of UP, which has also noted that the 35th report advocated for retention and in several subsequent cases decided by this court in which the death penalty was recognized to be deterrent. It laid emphasis on then recently added section 353(2) and 354(3) CRPC, which provide for bifurcated pre-sentencing hearing and sentencing procedure on conviction of capital offences to conclude that this form of punishment continued to have legislative backing and thereby
You can
represent.
come to the relevant paragraph. Is
Lordship.
that a discussion?
Then, Your Lordship, 218. Yeah.
Because all the factors have been laid down
Lordship,
in this case.
Lordship. It is reference to Machi Singh, Bachchan Singh, then your Lordship, other judgments. Then your Lordship may kindly come to 228. This is the reason why your Lordship uneven application of this framework and inconsistency in sentencing. Then again, reference to certain judgment, your Lordship. Your Lordship may straightway come to 238 then. Pre-sentence hearing, opportunity and obligation to provide material to the accused.
230?
8.
Mitigating and aggravating are from Bachchan Singh.
Bachchan Singh, your
Yes.
Lord. The court in Bachchan Singh has held that the introduction of pre-sentencing hearing to the accused in 1973 to section 235(2) CRPC altered the Jagmohan Singh principle that the court is primarily concerned with the circumstances connected with the crime. Therefore, now due consideration has to be given to the circumstances of the criminal as well as the adjudicating whether the case falls within rarest of rare. And if the option of life imprisonment is an alternative is unquestionably foreclosed. In Bachchan Singh, this court categorically stated the probability that the accused would not commit criminal act of violence that would constitute a continuing threat to the society is a relevant circumstance that must be given great weight in determination of the sentence. The sentencing hearing contemplated under section 235(2) is not confined merely to oral hearing but intended to afford a real opportunity to prosecution as well as the accused to place on record
You
facts and
come to 250, 251.
Lordship.
Because out in 249, the
Lord.
mitigating factors
Lord,
in Bachchan Singh, after mentioning that 250,
Lord.
please read.
249, 250 only.
250.
Next, the state must in a time-bound manner collect additional information pertaining to the accused. An illustrative but not exhaustive list is as follows.
This
Age,
is also not exhaustive. See,
Hmm?
this is
Yes,
only
Your
a
Lordship.
matter of illustration.
No,
It may be more.
more. Age, early family background, sibling, protection of parents, any history of violence or neglect, present family background, surviving family members who are married, his children, etc. Type and level of education, socioeconomic background, including conditions of poverty or deprivation, if any. So criminal antecedents, details of offense and whether convicted or sentence served, if any, income and the kind of employment, whether none or temporary or permanent, etc. Other factors such as history of unstable social behavior or mental or psychological ailments, alienation of the individual, with reasons, if any, etc. These information should be mandatorily available to the trial court at the sentencing stage. The accused too should be given the same opportunity to produce evidence in rebuttal toward establishing all mitigating circumstances.
Yes.
Lastly, information regarding the accused jail conduct and behavior.
See, even the
Yes,
jail conduct.
Jail conduct, Your Lordship. Behavior, work done, if any activities that accused has involved themselves in and other related details should be called for in the form of a report from the relevant jail authorities, that is probation and welfare officer, superintendent of jail, etc. If the appeal is heard after a long hiatus from the trial court convictions or the high court confirmation as the case may be, a press report from the jail authorities is recommended for a more exact and complete understanding of the contemporaneous progress made by the accused in the time elapsed. The jail authorities must also include a fresh psychiatric psychological report which will further evidence in the reformative progress and reveal post-conviction mental illness, if any. It is pertinent to point out that by this court in O'Neill versus State of Maharashtra has in fact directed criminal courts to call for additional material. Many a times while determining the sentence, the court takes it for granted, looking into the facts of a particular case, that the accused would be a menace to the society and there is no possibility of reformation and rehabilitation. While it is the duty of the court to ascertain those factors and the state is obliged to furnish materials for against the possibility of reformation and rehabilitation of the accused, the facts which the courts deal with in a given case cannot be foundation for reaching such a conclusion, which is already stated calls for additional materials. We therefore direct the criminal courts by dealing with the offenses like section 302 IPC after conviction may in appropriate cases call for report to determine whether accused could be reformed or rehabilitated, which depend upon the facts and circumstances of each case. We hereby fully endorse and direct that this should be implemented uniformly as further elaborated above for conviction of offences that carry the possibility of death sentence. Your Lordship may also come para 254 while considering that particular case, Your Lordship.
254.
254. On an application of the Bachchan Singh test as clarified and explained in numerous decisions elaborated above. However, the mitigating circumstances need to be considered, and that too liberally and expensively, Your Lord. Prior to the hearing of sentencing before the court, a direction is issued to the state to, on the basis of personal intervention prison records, file each of the accused a psychological evaluation report, probation officer's report, prison report, including material on the conduct and work done. Furthermore, each of the accused has placed material on record before the court. And, Your Lordship, these are the, Your Lordship, conditions, Your Lordship, on which, Your Lordship, before giving a sentence of death sentence, the learned court below ought to have been taken note of, Your Lordship. That has not been taken note of. The age is also one of the factor which was not, he was 21-year-old at a relevant point of time. Now, another judgment. This, Your Lordship, has already gone through 2019-10 SCC 300 crime test and criminal case. That's not it.
Mr. Chaudhary has
Lord, this is, Your Lordship, 2008. 767.
this crime and criminal test is which paragraph?
That is, Your Lordship, 2019-10. Para 12, Your Lord. This judgment, Your Lordship, para 51. Para 51, 52, and 53.
So Ms. Ardhanan has also been, I think, the other day has been discussed, but still, Ms.
Lord.
2000 and
The truth of the matter is that the question of death penalty is not free from the subjective element, and the confirmation of death sentence or its commutation by the courts depends on good deal on the personal predilection of the judges constituting the bench. The inability of the criminal justice system to deal with all major crimes equally effectively, and the
you're
want of
reading paragraph?
paragraph 51, 52, and 53. Small paragraph. The 52, the inability of the criminal justice system to deal with all major crimes equally effectively, and the want of uniformity in the sentencing process by the court leads to a marked imbalance in the end result. On the one hand, there appears a small band of cases in which the murder convict is sent to the gallows on confirmation of his death penalty by the court, and on the other hand, there is a much wider area of cases in which the offender committing murder of a similar or far more revolting kind is spared his life due to lack of consistency by court in giving punishment, or worse, the offender is allowed to slip away unpunished on account of the deficiencies in the criminal justice system. Thus, the overall larger picture gets asymmetric and lopsided and presents a poor reflection on the system of criminal administration of justice. This situation is a matter of concern for this court and needs to be remedied. These are some of the larger issues that makes us feel reluctant in confirming the death sentence to the appellant, Your Lordship. Honorable Apex Court, even on these grounds, Your Lordship has, and in fact, Your Lordship, this is just for Your Lordship consideration, not judgment as such, Your Lordship. The matter of framing of guideline for death penalty that is presently pending before a larger bench, Your Lordship. That it was it is a Your Lordship will, this is your Lordship, for framing of guidelines, this is presently pending. 2022 SCC online SC 1246. 22 SCC online SC 1246. This is Your Lordship just for reference. It is a guideline. Honorable Apex Court has Your Lordship placed three judge benches placed this matter before for consideration by a larger bench of 5 judges, Your Lordship. In fact, Your Lordship, if Your Lordship takes up the judgment on the point of sentencing, Your Lordship will find page 759 how the Honorable Court dealt with page 759. Para 260.
Yes,
Your Lordship may also, Your Lordship refer to para 257. Besides individual factors, following mitigating factors are common to all the accused persons.
Mm.
All the accused are belonging to tea garden tribes and they are backward in both socio-economic fronts. Most of them are illiterate and some of them even do not know how to read and write. They are of young age and almost all of them are below 40 years. They have no criminal antecedents. No previous conviction is proved against them by the prosecution. Most important mitigating circumstances, Your Lordship, which they fulfill, Your Lordship. The Sanjay Rajwar. Now, Your Lordship may kindly come to para 260. Now, as held by the Honorable Supreme Court in Sushil Sharma versus State of NCT, and the endeavor will be made to examine independently following mitigating circumstances of the accused Sanjay Rajwar versus son of Babu Rajwar to determine the quantum of sentence. The age of criminal. We find from the statement of the accused Sri Sanjay Rajwar that his age is just 21 years. In the case of Ramesh versus State of Chhattisgarh, the age of the accused is recognized as a relevant mitigating circumstance, but it is not a determinative factor by itself. In Dayanidhi Bisway versus State of Orissa, AI 2003 Supreme Court 3915, age of the accused and dependency of all his parents were not considered as a reasonable ground for reduction of sentence. In Purushottam so-and-so versus so-and-so, Honorable Supreme Court has held that age of the accused cannot be paramount on consideration as mitigating circumstance. In the particular factual metrics of the case in hand, also considering the totality of circumstances and the role played by the accused in exterminating the doctor, we are of the view that his young age could not be determinative factor in not awarding the extreme penalty. Social status. First paragraph, you will receive reference to the judgment. Second, in the case in hand, accused Sanjoy Rajwar and the rest of the accused belongs to Tea Garden community, but it is not that the offense was committed because of backward socioeconomic condition. He is a permanent worker of Tea Garden. He is not sole breadwinner of his family. His mother is also permanent worker of Tea Garden. He was defended by a lawyer engaged by him. There was no hindrance at any point of time to have access to justice. His background. Though the learned counsel for the convict submitted the accused are of poor tea garden laborer, but there is nothing on record to show that there was limited information and limited participation in political and social life. These are, your lordship, findings is absolutely, your lordship, presumptive in nature, your lordship. Means, and they are disregarding the law and their rights, which constitute a real obstacle to access to justice. It is not the accused Sanjoy Rajwar is illiterate. He is defended by a lawyer engaged by him. It is held by Honorable Supreme Court in so and so that family also cannot be considered as a mitigating circumstance, and accordingly we find that this circumstance is also not favorable to the accused. Whether he is a confirmed criminal or not, or whether he had any antecedent. The learned counsel for the convict submitted that the accused Sanjoy Rajwar has no criminal antecedent, but we find that he has acquired all tactics of a hardened criminal. He threatened the witnesses not to adduce evidence. There is no material to that effect, your lordship, that he has threatened any witnesses in court against him so as to get rid of classes of law and to thwart the judicial process, thereby stultify the cause of the justice. Moreover, he has leveled allegation against the investigating officer that he was compelled to hold a glass piece while collecting fingerprints at the central jail. That is, your lordship, he has said, your lordship, in his evidence, that fingerprint was, I was forced to put my hand in the glass, your lordship. Based on that, your lordship. Since, your lordship, that has not been, your lordship, properly, your lordship, questioned, I have not argued that point, your lordship, but it is specific. Specifically, he alleged that forcibly his fingerprints were taken. That's why, your lordship, there is a question put by the defense whether there was any independent witness or not, your lordship. That they have denied it.
No, so far as comparison is concerned, his fingerprints, otherwise will have to be taken. See,
No.
that glass piece was collected from the scene of crime. And his fingerprints were later samples were sent, then only it will be matching.
That his allegation is that, your lordship, he has stated this before the court also, honorable court also, that, your lordship, in other glass piece also his hand was, fingerprint was forcibly taken, your lordship. Without making any attempt to establish the same by adducing any evidence, let alone a convincing one. This reflects his mindset. Therefore, to our considered opinion, these circumstances do not favor him. We derive authority holding from a decision from the Honorable Supreme Court in so and so, wherein it has been held that lack of criminal antecedent also cannot be considered as a mitigating circumstance, particularly taking into consideration the nature of the heinous offense and cold and calculated manner in which it was committed by the accused. In the case in hand, also considering the heinous nature and cold and calculated manner of committing the offense, these circumstances cannot be considered as mitigating circumstances. When there is any possibility of reformation, the possibility of reformation and rehabilitation will not be there, as he never shows any repentance for his conduct. The way he revived the appeal of the management and the way he snubbed the appeal of the law and order magistrate and the way he attempted to get rid of the classes of law through the judicial process by threatening the witnesses. The way he threatened the police personnel, prevented them from taking injured doctor to the police vehicle, chased away the 108 ambulance, and the way he wrecked the property of the hospital creates havoc, shows there is no possibility of any reformation. He did not possess any basic humanity and completely lacked a psyche or mindset amenable to any reformation. He has at least regarded the law enforcing agency and also the management of the garden in which he was being employed in a permanent worker. He tried to assault PW9 police personnel while he tried to protect the doctor from being assaulted. Whether it is a case where reformation is impossible and accused likely to revert to such crime. As we find no possibility of reformation as well rehabilitation, there is every likelihood of committing such crime in future also, as he acquires the tactics of getting rid of classes of law and in thwarting the judicial process, therefore the accused becomes threat to the society, given the role played by him in the occurrence. Now, Your Lordship, on this basis, Your Lordship, mitigating circumstances where Your Lordship discarded, and he was given the punishment of death, Your Lordship. Only last, Your Lordship, his one free statement, Your Lordship. He only says, Your Lordship. Put a few cards. Two 49, Your Lordship.
249.
Two. Your Lordship will straightway come to page 259,
259.
259. What do you have to say about the allegation against you? He replied that those who assaulted the doctor are outside the jail. I am innocent. And then, Your Lordship, in 253, Your Lordship, question number 14. Your Lordship will kindly page 253. Question number 14, Sri Gopal Bora deposed that he has seen you breaking the glass panes of windows and then with a broken piece of window glass pierce into the right thigh of Deven Dotto. What do you have to say? False statement. I came to know from Mukul Rajwar. His name is there, but Your Lordship, he was not examined by the police. Pavan Maji and Sandeep Rajwar that one Ramesh Rajwar caused the injury. Now, Your Lordship, nobody knows, Your Lordship, if among these 6 protected witnesses, Ramesh Rajwar is there or not, Your Lordship. Nobody knows, Your Lord. Now, it's an important question we could have put to him, Your Lordship, had Ramesh Rajwar been there, Your Lord. In my humble submission, therefore, this is even assuming that the finding of the honorable court so far as the guilt of the petitioner is correct, Your Lordship. Even then, Your Lordship, this is probably not a case for death sentence, as has been held by the honorable apex court in Katena. Even in Manus, Your Lordship, the honorable court has referred to law commission's report, Your Lordship. I have copy of that if Your Lordship want to have it, Your Lordship, I can. Nalai.
That has been discussed in Manoj.
Discuss that law commission. Which has in fact, Your Lordship, called for abolishing it, Your Lordship. This much, Your Lordship.
We'll resume when? Tomorrow we'll try to finish. Tomorrow we'll try to finish.
Lord.
বেলেগ থৈ দিবা এটা বেলেগ ফাইলত থৈ দিবা বেলেগ এটা ফল্ডাৰত বেলেগ ফল্ডাৰত থৈ দিবা Yes, continuing with his submission, Sri S. Bodhapur Learned Counsel for the appellant has concluded his submissions. What's the para? List tomorrow for the submission by the other learned counsel. We'll give priority to this case.
Lord.
Single bench assembly. No, okay. We'll just sit immediately, single bench, one judgment. In the conspectus of the aforesaid discussion, this court is of the opinion that no case for interference is made out by the petitioners. This court has noticed that the petitioners Vimal Kaur and Dr. Monalisa Chaudhary has already been promoted to the post of deputy director. In the case of Dr. Chaudhary, Rule 28 has been pressed into service by the departments. In the said exercise, however, though the case of the petitioner Renu Bora was considered, she has not been given the promotion. As observed above, though promotion cannot be claimed as a matter of right on the length of service itself, since the relaxation powers were exercised, it is directed that the case of Renu Bora be considered afresh by invoking the aforesaid rule of relaxation. Such direction has been issued as the aforesaid incumbent Renu Bora appears to be on the verge of her retirement and had joined the department in the year 1996, and admittedly vacancies in the cadre are still existing. The aforesaid observation also is made in as much as in the note sheet. It has been recorded that there is urgency as well as exigencies for filling up of the post. It is accordingly stands disposed of. Copy of the notes is made with the records.